not removed within 2 weeks from the appeal shall stand.
Some of the date losses, you are the member of the.
He has become member of the GST appellate tribunal, so he has to go somewhere.
Adjournment for 2 weeks, you find out then on the record his name on behalf of Mr. Prashant. You just dictate that. He is not no longer there in the profession.
Item number 3.
Just record so that in future, at least somebody will know. That's why we have it. Yes, give me 5. Yes, sir.
Here your wordships, annexure 1 is the input. Let page 19. Let here the.
Just 1 minute.
Sorry.
Yes.
The 3 grounds are rejected. Firstly, the 18 calendar months is not wrong. That the clause provides 3 categories. One material for the 18 months, your lordship, and so and other classification, whole period including extended period. They have mechanical manner as rejected. Your lordship, kindly see the clause, your lordship. They have completely non-application of mind.
Where
without hearing.
Page.
Page, your lordship's page 35, annexure 2.
Which clause?
Your lordship 31A.
Clause 30.
AI, first lordship.
Clause 30.
31.
31.
AI, your lordship.
Yes.
Your lordship. If the during progress of the work, price of any material, excluding the cost of material, cement and bitumen incorporate the work not being material supplied for the engineer interest to, in accordance with the clause, if decrease in result, there are your lordship method, second clause, sub clause, your lordship. This clause will be applicable to the contract where
It's more than 18 months. Then
more than your lordship. My case is your lordship next clause, page 36, your lordship. 36 and 37, your lordship.
yes.
Page 36, your lordship. 31A, your lordship.
2.
31A, 2, your lordship. Reimbursement of recovery difference cost due to price. Principal material, steel, cement, bitumen price. If after submission of tender, price of steel, cement, bitumen and pipes not being supplied by the department increase or decrease beyond the price prevailing in the time date of submission tender, including extension for the work contractor, shall be eligible to get differential cost due to such hike on the value work executed during the stipulated period and during the extended period when the reason of delay in completion of work is not attributable to the contractor. If the penalty is levied for delayed completion of work, the contractor shall not be eligible get price variation on the.
No, I understand. So according to you, first thing is the difference is if the these materials like cement, steel and the bitumen is supplied by them, then you are not entitled to escalation.
Yes.
If you supply it, then within any variation within the period of contract or extended period, you will be entitled to reimbursement.
Yes.
Provided no penalty is imposed on you.
Lordship, annexure 6, my EOT approval, your lordship. Page 164, your lordship. I have given also types.
Yes.
This is related to sanction of EOT by the WATCO, your lordship. As per the recommendation letter reference approved in the 3rd meeting.
33rd meeting anyhow is a such as a proposal for extension of time from 13/1 to 36. Sanction, that's true, 2 years, 900 days.
Because COVID was there.
Such and such.
We without imposes a penalty, as delay is not attributable to the agency.
They will not complete. Where is your affidavit?
Your Lord,
They
that
also
affidavit,
talks about.
Next, Annexure 7, your Lord, page 166. But this affidavit part, your Lordship, was escalation was denied. It is for the purpose. There is a law department clarification I annexed that. It is only for the purpose of extension. Annexure page 166 and 167, your Lordship, both affidavit, two affidavit. Your Lordship. But 167 is the minority.
Yes.
Your Lordship, my affidavit, your Lordship, Annexure 167 is the.
I have already read it.
Yes, your Lordship, law department clarification, your Lordship. Annexure 10, your Lordship.
Page you give me.
219. 219.
Yes, your Lordship.
Yeah.
This
is work department.
Yes,
This is works department.
Works, no department. Your Lordship, second page 220.00. It is a typo. I have made a type here also, type copy. That the no claim certificate given by the contractor along with the application except type is the prescribed form down no affidavit clause 32 of the agreement containing stipulation from the price escalation, the review of the code and provision.
Just 1 minute.
Correct, and contract is not precluded the escalation after furnishing no claim certificate. And your Lordship, second para, go sir.
Yes, sir.
This is what I was having an impression. So clarification that the compensation and the escalation in price are two different concepts.
Similarly, there is no agreement below my humble submission that I will be extended period.
Yes, madam. If they have. What instructions, madam? It is very clear. Because the word, he has given an affidavit so far as the compensation is concerned for loss of work, for keeping the labor or the material or anything in idle. So for that he has suffered. So these are all the pecuniary losses which he can be compensated. But so far as the escalation part is concerned, the 33A2, 31A2 is a different concept.
Actually, this was if he is entitled to, they may calculate it in
What entitled to? We have to say that he is entitled to.
verification of document.
We have to quash it. We have to quash the order.
The law department clarification is of the year 1996, Your Lordship.
So whatever, the compensatory part and the escalation part are two different concepts. So
But
so you can't, that was, we were also going to say that these are the two different concepts. You can't say compensation and affidavit. You can't. And you are rejected on that ground.
escalation of claim.
No, he has surrendered this compensatory part. If you come to the affidavit,
166. Page 166, 167.
you come to the what he says, certify that we will not claim any financial compensation.
For the delay in completion of the work.
That's true.
We will not claim the benefit of price escalation during period of extension.
Where?
The next line, Your Lordship, page 167.
Yes.
Certify that IOB will not claim any monetary compensation for the delay in completion of the work.
Correct.
And herewith, we will not claim the benefit of price escalation during the period of extension from the department for the work, namely.
So it is only so far as the extension period is concerned. And so what about the natural period?
They have not also. Total period was rejected under Annexure 1 because it is they
Oh.
stated that 11th plenum.
Extension can be done, but what about the original period? And you did not supply the cement, steel, or a bitumen. It is they who supplied. What to do, brother? No. Just then,
Does
brother,
it come to the first?
let us step aside recording this, and in the light of this, let them aside the order, saying that these are the clauses, take into account this factor. This has not been taken into consideration.
See 31A1 that he was reading, the second paragraph in Lordship.
Yes.
Said this clause will be applicable to the contractors where original stipulated period of completion is more than 18 months.
True, but when you say that not being the material supplier, just imagine that excluding the cost of steel, cement, and bitumen incorporated in the work, not being the material supplied from such and such, with the clause hereof, increase and decreases. Now, if you come to the next, it says that the price of the steel, cement, bitumen, and pipes, this is what he is claiming the escalation, not being supplied by the department. So there is a distinction. One is supplied by the department, he cannot, and one not being supplied, then there is nothing which says that within that time he cannot. Because it says if there is a due to hike on the value of the work executed during the stipulated period and the extended period. Now, suppose can he, madam, again, an affidavit is sought. Do he has any choice? Was it not under duress? It is not under duress. What a contractor whose money is withheld, though he executed the work, what is supposed to do? So you are a model department. You have to take a steps. If you have incorporated a clause, can you force them to give an affidavit which really is against that clause? Where is the provision for affidavit? Where is the provision for affidavit? Take a conscious view. You have to be very, I would say, impartial. You have to do it in this.
After the 331A2, your lordship, reimbursement there, it has been written, if after submission of the tender, that the last line, if penalties level and delay come to
So that is what is there. Suppose if there is a delay which is caused by him, attributable to his conduct, the word is used is attributable to his conduct. Then if any penalty is levied, then definitely you will deny. You have not come up a single, when I think the stand, or not a whisper, that there is any lapses or a delay attributable to his conduct. Rather, due to the COVID period, you have extended the period and then he has executed the work.
Lordship may dispose of the matter sitting the order.
So this is what I feel is that what as per law?
Whatever I
We have to say that this. I have a very strongest of reservation and views on representation of consideration of representation. Strongest of reservation.
Matter whether there was any additional.
You have not. Then again,
sign.
Many a times I have reminded the state of Mahinda Singhal. If authority has not taken a particular point at the bar, you cannot improve the case. This ground is not taken by you that there was any delay attributable to his conduct. How can you at the bar take a point? No, no, no. Let the authority think about it, making them further wise.
Any other negotiation that have taken place or what I have.
Not a negotiation.
COVID time, your lordship, exceptional circumstances, your lordship. what-
No, then you'll have to take an exceptional.
Department and.
If it is an exceptional circumstances, then you'll have to take an exceptional decision. You can't put him. He has work. It's not that he has not worked, and there is a clause for escalation. How can you deny? No.
It should have been clause 31 actually.
The letter dated 30.
At or 4.
Because I'm a work contract. Same escalation reduction. Because we see in my case, it's got better. But given a recommendation for payment, they're not acting upon. Section 19 medicine.
Page number, sir. I
Page
don't.
number 153, sir.
One.
143.
Is there a typographical mistake in the letter where they say the work is 26/12/2006?
Yes.
It will be 26 or?
Yes, it is correct. 2006, it was granted. I completed the work in 2010. I was given extension of time. Thereafter, a dispute started as to escalation clause across Odisha. There various circulars came. In court interfered, lost it.
Kindly read this. 25/6/29.
25/6.
Just
That is what I also, that's a mistake, 2006 or 2029, what is there?
It is 2009. Completion is 2009.
That is what I really was surprised with that. That's why I asked.
29.
That is what, you are
2009. I'm
not
sorry.
keen in hearing what my lord says.
Yes.
He's very energetic, so a lot of energy is still a young guy, so he just wanted to exhaust.
Yes. 2009.
Has become emboldened by many things.
Yes, sir.
No case is so simple.
Yes, it's I think it's a very difficult issue at the moment.
Then how come this GST?
Because now the reverse they're charging on reverse valuation. So
In
that time there
2009 there was no-
was no
In 2009 there was no
GST. So they are additionally whatever they have to charge me, they're adding it up and asking it for payment. So
How can it be? How can you make a particular fiscal statute from a retrospective operation?
Let that this
And that
letter
too imposition of the tax on a new regime.
Yes.
that I have to take instruction in this.
Take instruction. So you are appearing, you do not know that's a new regime of tax. Can it be imposed from a retrospective effect?
GST cannot be ignored.
So how can you say that GST will be applicable in 2006, 2009? I think at that point of time it was a VAT or a sales tax.
That's
In 2005,
It was a VAT.
since 1/4/2005, there is that.
No. So
And madam, this letter on the annex 19 is it is recently addressed to the chief construction engineer. Millard. What happens at that end? Millard, let me take instruction. This matter come next week. Because the previous letter shows that there was a mistake on the part of the.
page 162 also, their letter is for release of the escalation, this one. You have not taken any decision.
Millard, if your lordship comes to annex 17, Millard, it is dated 1/7/2025 towards the bottom. It is stated that some bills were not submitted by the petitioner. Thereafter, he submitted the bill and thereafter this development.
Is
Some
it
documents they
conceivable,
didn't submit.
is it conceivable a works contractor since 2009 when he completes the work and he has not submitted the bill? Is it at all?
Millard, in the next letter they have stated.
So at his own peril and loss, he will not submit his bill. He
Certainly.
is doing his business, sir.
Millard, let's kindly come to.
A
annex
prudent
18.
businessman would not do this.
Yes, but annex 18, Millard, they have stated the fuel price, labor price, wholesale prices, lead forms, all are resubmitted.
And now the works contract.
Resubmitted means what? That there was already a submission.
Yes.
Resubmitted means, means again.
Yes.
I think you have
Submitted
lost it.
means give, fine.
You lost
give
it
a-
and you asked him to give a copy.
Yes.
Or-
Now,
or-
this letter.
How, now the works department again floated a circular dated 19/11/2019
It's only. Millard,
for the work done in 2009.
yeah.
Sir, I tell you very frankly, I have seen your prayer. Is a writ maintainable in this form? It's a pure and a simple case of a recovery of money.
There's an admitted due with us.
Tell
You
me,
pay- you
tell
pay
me,
state corporation.
tell me the law, because I know Justice Ravindra's judgment is against you,
But members,
and a subsequent judgment is also against you.
UP State Cooperative University is in favor of me.
No,
They are admitting.
no, no.
Also,
Show us,
I will also put all that.
show us.
Admitted due. Because they are recommending. Had this been my dispute, they are. I'd have-
Then wait till tomorrow. Wait till tomorrow.
I will also.
Wait till tomorrow and then argue.
Okay, Millard, I'll bring all the judgment. Millard is asking on the admitted use. I'll bring the UP State Cooperative also.
Writ jurisdiction.
I am not recovering, Millard. They are admitting. Had this been,
Sir,
they deny.
sir, even if there is, come, show us.
Yes, Millard. I will.
Is. Ah, yes, tomorrow.
Item number 5.
With both the matters. Issue, Millard. Tomorrow.
Keep it tomorrow. Yes, as per orders at the first one. It will be a first matter.
Much.
May I please yours?
Which one?
Hi.
Fine.
Petitioner, please engage in the installation and the construction of transmission towers and substations, high power substations. Office party, Power Grid Corporation of India Limited, owns power grid throughout the country and maintains transmission line for that.
Where is a clause for reference?
No, that's, yes, I'm okay. Page,
Where is a clause for reference?
annexure,
Give me the page number, sir.
105 minutes. 105.
Printed or written?
Huh?
Printed or written?
Written minute. Annexure 4, page 105. This is
100?
105.
Yes.
So dispute resolution through conciliation for contractual disputes in projects implemented by CPSUs, statutory bodies under the administrative control of Minister of Powers or conciliation committee of independent structure. This circular is
Just
issued.
1 minute. Is there any constitution of the CCI? Is there any constitution of the CCI?
They, this much I have got instruction, they are operating. CCI is operating.
There's a conciliation committee of independent experts
No, so it
has
is-
been
It's
constituted.
operating. That's why we requested them. If it will be costly if we go for any other method like arbitration, though we have arbitration. Even this satellite takes care of that millions. First we can see. Page 107, paragraph 6.
Oh, no, I understand.
And
Have you,
this is ADR. This is ADR, man. Completely ADR to be conducted under.
it's not a ADR. I will come. Is a ADR is a different concept. It will not, it says that it will not be considered as any alternative arbitral proceedings or something of that. So I understand. I'm just asking, sir. Just answer me. Have you asked for a reference?
Yes, ma'am.
Can you show me a
Next,
reference?
next document. Annexure 5, page 110. We requested that this is our dispute. And let's go for convenience of both the parties. It will be less expensive. Let's
Yes.
go first.
Yes, what is your stand?
I received instruction on late last night to appear below. That's the first motion. Was served the copies late last evening. 112 is our reply to this invoking this process.
Conciliation.
Yes, 112 is our reply.
No, that's a merit. That's a merit. They have not mentioned anything.
112 is our reply,
Sir,
and they have.
there are two aspects.
Sir.
One is when the government has issued a circular or memorandum that in all these respects, in order to avoid any kind of a cost being imposed, there is a constitution of a conciliation committee of independent experts. Says that in all the matters, the once the reference is made, request is made for conciliation, then it is inevitable. You'll have to go for conciliation.
I bow down to that.
How can you reject it? When you give a reply, that means that shows your mind state set that you are not ready for conciliation. You are putting a spanner to a conciliation process.
Kindly turn to 106,
Yes.
which is this notification which starts at 105.
Correct.
The notification is dated 29th December
21.
2021.
Correct.
Kindly turn to 106.
Yes.
It says the panel of independent arbitration
Correct.
experts shall remain valid for 3 years from formation and extendable by 2 years.
Yes.
Please permit me to take instruction as to whether any panel of such independent persons are available or not. That's
No.
number one. Number two, Miller.
This panel, there is a mechanism which is put into place.
Right.
They have constituted a body which is called a conciliation committee of the experts, independent experts. Now, who will be the members of those committee? That is also indicated in that office. Now, so far as their lifespan, their working, the tenure is definitely for 3 years, extendable maximum up to 5 years.
Right.
It does not mean that the entire mechanism is taken off. It is only who will man that particular committee.
I bow down.
For that, this is a 5 years period.
I bow down.
Still, if we consider it, now till 2026, there is no difficulty.
Look, 3 plus 2. Let me come back to your lordship.
No.
Short span of
No.
time. Second, Milord. This contract, as I
How
see
can you
it,
deny? We are not, whether they are there or not, you have not taken the decision. You have simply denied that we are not going for a
No,
consideration.
they have replied to that also saying we do not agree. So dispute is created undoubtedly.
So that is why unless there is a dispute, there is no question of any conciliation or an adjudication.
But additionally, one other aspect, this relates to an OPTCL line. Maybe OPTCL is the interstate transmitter of electricity, intrastate transmitter.
Yes.
We are the national grid.
Yes.
Therefore, maybe OPTCL also needs to be a party to this case. With my most respectful
Sir,
submission,
who is supposed to resolve the dispute? Who floated the tender?
But my
You-
contract to which
Just, I am coming. I am putting a question like a lawyer. Sir, when you floated a tender, you entered into the contract, the dispute arises from a contract. Who will decide? You or a third party?
I will decide.
So, why don't you take a decision?
Let me come back to you, Lordship.
Former officer of the secretary or the additional secretary to the government of India,
Right.
then a sector expert. That's why the independent body.
Absolutely.
And then expert in the finance.
Well,
So independent body. They will consider it.
Lordship, call it in a short day. Give me a short date.
No.
We'll come back to this first motion. My client doesn't even have notice of this. It's the first motion. And
Why he was given us a copy?
No, Milan. This was last night at 10 p.m.
Who gave?
The petitioner served the copy at 10 p.m. last night. Otherwise,
Not a 48 hours, sir.
No.
if I had noticed earlier, I would be ready
It
with
came for the
instructions.
first time. I had given memos. It came for the first time.
Sir, I am of the view that any writ petition, if it is filed, it should not be listed before 48 hours, official hours.
No, it has filed long since.
So why you did not serve immediately? Why you did not serve immediately? They say you affect the service last night.
I was hoping this month.
That is what is there, because in Calcutta, there is a rule. In the rule itself, it is incorporated that no writ petition shall be listed unless the copy of the writ petition is served upon the authorities 48 hours before the date of listing.
And we also do.
So that they get this 2 days time to take a necessary instruction.
No, we don't know who will be appearing for this purpose.
Sir, you'll have to send it to the department. And if you know that they are I say the organ of a central government or an organ of the state government, then you can approach either the DSG, you can approach either the AG office, and you can serve the copy. They will take care of that.
We'll take care of that. That in future we'll take care. Nice of him, he called up.
This is-
That this matter is listed. and not taken.
In fact, the briefing advocate called me last night saying this is a matter which has come up. So it was
On the request of
Dear Manoj, the annexure fees and the challenge Manoj, page 22. The option is only issue involved is that this is a circular issued by the state, a standard operating procedure Manoj SOP, wherein one of the clause is only under challenge, that is clause 3C3 Manoj. That is at page 24 Manoj, relevant page 24. We are the petitioners association, they are all stone crusher units, Manoj. They have all the
So it's a very, very noble way, the written consent from a quarry leaseholder. If the applicant does not possess a quarry lease, can you make a quarry without a quarry lease?
Manoj, that is the whole point. We are not making the query. Manoj, the fact of the case is that we are all the stone crusher units. We have been having all the valid consent to operate and consent to
Yes.
establish from the State Pollution Control Board.
Sir, from where you are getting this, these stones for crushing?
Manoj,
Tell
the
me.
quarry lease holders.
Correct. If he gives the written consent, yes, I am supplying you. I am giving.
Manoj, the whole difficulty is that they are saying that under the I4MS portal, in order to get ourselves registered under that portal, first we have to obtain a written consent from the
True.
quarry lease. But that is the only difficulty because
In order to streamline that
My lord,
Sir, there are many things which happen, which is happening and which is being noticed.
my
Uh,
lord, that I4MS portal is only for regulating the
multiple the query lease holders just
So, my
give
lord,
the,
the clause itself is vague because my lord, there is the petitioners won't be able to get the a particular consent from any particular.
sir, what you did not understand what I said.
My lord.
You are a stone crusher unit. You're not concerned that from which query lease holders it is coming. Whoever comes and gives you a lump for crushing, you crush it. So you may be doing a multiple, operating a multiple leaseholders job. Correct. Why don't you take a consent from them? Whenever he supplies a goods to you or a lump or a big one, he will give a consent that I am a leaseholder. I give you a written consent for crushing. That's all.
That clarity.
One line.
The petitioners.
That is what is required.
Time they will get
Written consent.
and for getting themselves registered members. In order
It is not that getting themselves registered. You are, sorry, approved citing criteria for consent. I do not
The
know.
petitioners poses no.
Copy of, you are challenging only 3, sir.
Three,
That's all. That's all.
Three.
So the 3, I does not find anything. Other grounds, you are not. You are agreeable for registration. You have to go for the registration. There is no difficulty.
If the lordship may kindly see the first paragraph, page 24.
Yes.
They have stated that in excess procedure for registration of stone crusher units under I4MS portal, in excess of the powers conferred under Rule 58 of the OMMC Rules 2016 and with a view to streamline the process of regulation and monitoring of stone crusher units, the government of Odisha hereby issues the following procedure for the registration of stone crushers through the I4MS.
True.
So, Manoj, the problem is that unless they get themselves registered, they won't be able to, Manoj, carry out their business.
They have to.
But,
They have to. The purpose is very laudable.
But my question, Manoj, I may pose myself from where they will get the written consent and what time?
From where? When the supply is affected, along with the supply, there will be a written consent. They did not say that it has to be submitted or thing. Only they say written consent from a query leaseholder who is supplying you a lump to have the stone crushed. That's the only thing. You did not have to submit to them, but only thing is that when you receive the goods, there will be a written consent from the supplier that yes, I am a query leaseholder, I am supplying you, do it.
Prior to this is the prerequisites they have given. So, in order to carry out the
When the supply is done, there is nothing which cannot be done.
The registration process, unless I get myself registered first, I cannot also invite any.
So you go for a registration, you are doing a crushing one, you are getting it from a query leaseholder, get the written consent and give it to them.
The only thing is that let them clarify this clause at least because this is
No. Then you.
Because my registration is affected at the beginning,
No, sir, I don't.
Because let them first. Only the subclause 3 is under the issue is creating because that is only creating the hurdle for the petition.
Just to track down the legal source.
That an individual or entity intending to operate a stone crusher for processing minor minerals shall apply for registration in formal. They have given the formal also. I am ready to get myself registered, but this clause is only getting as a hurdle for the petitioner to get the registration. The whole clause itself, it's totally unreasonable and vague also because they have not clarified how to get the consent.
The instant
May only observe if they are having any grievance, they may approach the authority.
We can't open an avenue for them. We can't.
Item 7.
Lease deed was executed between the state government through mining officer along with.
Only to consider the representation.
Yes, ma'am. That might there, but your lordship kindly see what happened. After the lease deed was executed over my area, my lord, a bridge was constructed by the state government, for which I am unable to use the entire area of mining lease, sand area. So I approached the Tahsildar.
The bridge is crossing above the mining area
Yes, yes,
or
Yes.
adjacent to or
crossing over the mining area, crossing over my sand soil area, which was executed, which was laid out in my favor for a period of 5 years. In the meanwhile, only 1 year has been completed. 4 years has already been left, man. And now your lordship kindly see the map.
so
The plot number is
the bridge
160.
was not constructed overnight.
The bridge was already constructed after the lease was executed, man.
I am asking you, sir, the bridge cannot be constructed overnight. When you got the mining lease, are you not, whether you were not aware that there is already a bridge which is put in place? And the quarry or a mining has to be done in a restricted manner? You, with your open eyes, you participated.
The tender.
Now you are flagging an issue.
No,
Look, I can't do it.
let me explain. The tender was of the year 2020, but due to pandemic, the lease deed could not be executed
I
till
am asking when the
2024.
bridge was constructed, sir.
This 2023 and 24, mine.
This was constructed in what, in 2 years? Or it is started well back before 2020?
No, it was not started before 2020, mine. It was not started before 2020. Let them obtain instruction. I only approach the authorities to.
What is your instruction?
Malats, I don't have instructions.
And
Yes,
you
ma'am.
work.
1 week, Malats, I'll take instructions.
That's a very usual way here. It's a,
Malats, I tried to take instructions in this matter, but I have.
when you were served with a copy,
This was served on 26/9/2025.
what you were doing from September, the whole of October. Now we are at the fag end of the November. 2 months time has already been given to you. Could not get the instruction.
Let's,
Only first time. That is what I really wanted. I may be taken in a different way, but this kind of a practice, and this augments the tendency in this call. This is the reason. With all humility.
Lead out in my favor, which is a vacant area, in order to operate the lead.
Item number 8.
Out of two rejection in one order. One had come earlier in the last week. The rejection order is at page 36.
Huh?
There are two, on the tender, my tender was rejected on technical ground, page 46. As per clause 4A, section.
Where is this clock?
Yes, ma'am. At page, page 15.
1-5.
Yes, one. Only thing in my tender, I had not calculated as per their requirement. I had given all the data I had given. I've given memo, your lordship can receive the calculation. Bid capacity calculation. I have made me laugh. Yes, I've given, an advance I've given.
now, Malats, just now, Malats.
Just now, I've given. This is a calculation only arithmetical. Yeah, all the data are there, but the co-applicant.
Have they supplied these full?
No, Malats, they had not given it in the prescribed form, Malats. If I may hand over the instructions in this matter. Malats.
But I give the annex 6, your lordship kindly see of another two applicant.
They must also provide the calculation, why they consider it not eligible or qualified.
My lords, if I may refer to the instructions, my lords, clause 4A and the relevant portion is quoted in the instruction, my lords. And accordingly, there is a form in the bid document, my lords. All those documents were not submitted in the prescribed form. He has only given a certificate.
Where is the necessity of submitting the document in 4A?
Yes, my lords.
What is that?
Page number 15,
No,
after note 1, my lords,
no, page number 50.
of the 15,
No,
note 1, just before note 2, my lord, after note 1.
yes.
The statement showing the value of existing commitments and ongoing works as well as the stipulated period of completion remaining for each of the works listed should be countersigned by the engineer in charge not below the rank of executive engineer, my lord. What he had submitted is at page number 36, my lords.
It is not countersigned by the engineer in charge.
No, my lords, he had just submitted a letterhead. In his letterhead, he has mentioned that his bid capacity is 15 crores, my lords.
Where?
Page number 36, my lords.
36.
6.
So this is for him.
Yes, my
But
lord.
it talked about will be countersigned. Where is the countersignation?
My lords, and also if I may refer to third page of the instruction which I have given, my lords. It is a form N, my lords, where the big details of other works tendered for and work in hand on the date of submission of the tender. This is
Where it talks about
work in hand is,
in this clause 4A.
my lords, page number 15 only, my lords.
Where it includes connection.
My lords, if I may read the bid capacity, my lords, applicant will be qualified only if the available bid capacity at the time of bidding is more than total estimated cost of work. The available bid capacity will be calculated as per this, my
You have given
lords.
a form. Then
Yes, my lords.
Hmm.
And then they have to disclose everything in this format, my lords.
where is the form?
Form M, my lords, instructions.
Where it forms part of the DCCL.
The entire
And
DTC
clause
is
4,
not annexed.
Clause 4.
But the entire DTC is not annexed, my lords.
You also let's say the person who was selected, who has been found suitable, page 58.
Form N.
He has not given it in any form.
M.
What my friend is saying now,
50.
58, high grade.
Application for grant.
Not a single person has given it out of 6.
Page 30 also. P0.
He has only calculated, I have not calculated. That is the difference.
This P0.
This is not also in form. And previously I have got 10 cases, 10 option on the basis of this certificate only.
No.
For the first
It
time,
all depends upon the value of the contract.
yes, value it
Because it
exceeds.
says the estimated cost of the work must be.
Yes, I've given a calculation,
There should be more.
it's 17
I
crores.
understand.
17 crores.
Other tenders may be of a higher value or a lower value. Lower value, probably. So you have.
I have a higher value minimum. I have that, but in the technical word bid, they have to only see that whether I have worked or performed this work or not. More than the estimated cost. Here estimated cost is 8 lakhs, 8 crores.
Capacity.
Estimated cost is 8 crores somewhat. You'll also kindly see particulars at page 12. It is only 8 crores 33 lakhs. My capacity is 17 crores somewhat. I have calculated as per that calculation. So if it is not in form, not a single person has given it in format. If you also call for the record.
They have disqualified. These
Calculation sheet, my lords, because it was Saturday, Sunday, I could not.
Only one word. Historical.
Yes, my lords, only that.
So what is the reason? How is it not calculated, the similar work?
Because my lords, the instruction which I received, my lords, because it was not in the prescribed format. And hence it was not calculated because only a undertaking was given by the
How they have calculated?
form and my lords. Along with the instructions, my lords, page number, third page, my lords. Yes, my
As well as the stipulated fee completion remaining for each of the claims listed should be countersigned by the.
Here also page 58 no countersign. He has been selected.
Format, what format?
That's along with the instructions, my lords, I had submitted, my lord. Third page, my lords, form, and it also talks about the same thing, name of the work with the date of agreement, place, tender cost, along with the instructions, my lord.
No, you show me from where it is getting.
The entire,
Now I'm coming. I got your point, but now I'm asking a question. Where is the condition prescribed for submission of those certificates? In format.
and this talk about the anticipated date of completion, amount put in tender. So this will technically specify what is the bid capacity, my lords.
Which has not been submitted to the agency during online term. We was given an entitled the certificate letter. Everybody. What will be this is this place is what we done. That doesn't.
That I understand. I understand. I'm asking this question. Come to 4A, bid capacity.
Yes, my lords.
You do not find any kind of a
Reference to form M.
nothing.
No, no, that I understand.
Come to at the bottom of the same sheet. The bidder should submit the attested copy of the certificate of authenticity in the enclosed bidding document to the concerned officer charge of execution regarding the execution of the major items of work during last 5 years. 5 years means to the financial. So this is how they wanted a authenticated certified copy of
Yes.
the work. He wanted to say this.
Yes, my lords. This is the reason, my lords, which has been.
Then come to your own paper. Here. Your own document, which you supply. Page number is not given. You got
Yes, my lords.
his name appears in serial number 3.
Serial number 3.
What you have written?
Except clause 4A, my lords. The bidder satisfy minimum eligibility and qualifying criteria as per BTC and clause number
So,
4B exception.
That means he has complied all the formalities as per 4B. And this page 15 bottom that comes under 4B. Not under 4A.
Yes, my lords. Yes, my lords.
So according to your authority, 4B is fully complied by him,
Yes, ma'am.
except 4A.
Except 4A.
Where is the difficulty? Now tell me. 4B is complied, then why Form M? Because last line talks about the format. The total work executed must be authenticated, everything is to be done.
Because on the basis of 4A, the bid capacity has to be calculated, my lords. Now, this document which is submitted, he says that his bid capacity is more, my lord.
You are improving your case by virtue of this.
No,
By
my lord.
virtue of your instruction, you are improving in your not in details, everything.
My lord.
Simply you say that
Except
it
for-
did not come, he did not meet the requirement of 4A.
4A, yes, my lord.
Yes, please. The other is say, yes, he meets the requirement of 4B. That means he is found eligible in 4B. 4B talks about satisfactory completion of a singular major item of works. The bidder should have executed minimum quantities of critical item of work as executed in any 1 year following minimum quantities of the detailed correspondences and which such and such of the authority issuing certificate shall be furnished.
Yes, madam.
Reinforcement scheme, cement concrete, or such as this sum total of similar items in all work executed in one dimension. These items might have been executed in different years subsequently separately in last 5 years, including the financial year of the invitation of bidder. The bidder should submit the attested copy of the certificate of eligibility in the enclosed bidding document from the concerned superintendent engineer of execution regarding the execution of the major works in last 5 years. The bidder should have executed and completed the work within 5 years and including current financial.
That's 4A, my lords, respectfully, my lords, talks about two things. One is completed project and two, the pending project. And the calculation thereof will entitle what is bid capacity, my lords.
Because you just make a term. Now you are improving that he has not furnished the document as per form and he has not furnished the document which is required. You are really transgressing therefrom. If you say that these are the works which he disclosed, if I put in into the formula, he does not meet the requirement, we are at fault.
Right, understood.
We will not believe his statement. It's a simple mathematical
Yes,
calculation.
madam. Bid capacity has to be more than what that can.
When you talk about something more, then how 4B compliant, 4A, except the calculation part, no other, no other no other factors can be taken into.
Yes, madam.
If that being the position, he has given a formula,
Now, my lords, he has given this, my lords.
sir, and if he goes beyond 70. And what is the total estimated,
Sir, 8
value
crores,
of,
8.30, my,
what is the total estimated value of work?
8 crores.
8.33,
8.3.
33 crores,
And your formula
70,
says 17 point something crores.
Because it, my lords, I'll just take instructions from this, my lords, because
What more instruction?
what I have been given is this,
You
my
can't
lords.
improve, you can't improve.
What I have been given is this because it was not given in the prescribed format, my lords. Hence, the bid capacity could not have been calculated.
Indicated, your instruction, it does not appear that these documents is not countersigned by the executive engineer.
No, my lord, they just say because it is not in the format, my lords, and hence the bid capacity could not have been calculated.
No. There is no other way because the clause 1, the first portion does not apply to it because it's not a case of a joint venture.
No, my lord.
The only thing is a statement showing the value that he has done should be countersigned by such and such. That's all.
And as well as the stipulated period of completion of remaining work. Form M talks about the pending work, my lords. That is what is not given by the petitioner.
No words.
Well, if I, one just.
Sir, I understand. If somebody does not have any pending work, he has completed the work within a period of 5 years. Does it make him disqualified? It's only for the purpose of this formula.
Yes, my lord.
So,
For formula, my lords, you have to disclose all the entire information, my lords.
I'm giving, in each and every thing I've given. Sir,
you are not a favored child. What can be done?
Details of.
That form and you talks about.
My lord, in the instructions, my lords, I have given, my lords.
4A doesn't speak that well. 4A doesn't speak that well. It says from instruction, as the book, Millard, I have got the book. There is a, Millard, there is a table, there is a format. But nobody has given as per this format,
Here,
including
financial-
Gopal Rao, who has been selected. Then 58 your lordship see, he has also not given him, not a single person, all 6 persons, not a single person.
My lords, here financial.
But I have been disqualified.
The decision of the
order after the amendment come into force and before the judgment of this honorable court, wherein identical matter, your lordship says please to last week. Same Tahsil office, same party, different source has pleased to pass. Only the Sairat name is, other is all are same.
You seen that
Yes, my lord.
after the amendment having brought
Yes, my lord.
want of jurisdiction.
Yes, my lord.
Item number 10. So,
Please, losses. We should give sand polymer losses kindly. Understood. 3 losses. Yes,
Where is the problem for extension?
losses.
Where is the provision for extension of the query periods?
That is already expired. That is in the 5 years losses. That is, and it's a one loss.
I am asking you wanted your prayer is to extend 1 year. Where is the provision
that
under
the one-
under the rules that the state government has the power to extend?
No losses.
There must be legally enforceable right.
No losses. I simply claim a loss. I get 5 years for the original loss. 1 year I not extended because the
True, because you could not operate.
losses.
Correct. When you come to the court, that you must have a legally enforceable right. What is your legally enforceable right? Is there any provision for an extension that in extraordinary exceptional circumstances, the government can extend? It is a mutual, contract is mutual. So can we, you have to satisfy the court.
Losses I simple prayer because the I give a defendants they consider if they reject then I come
not
with
believe it. Your right should emanate therefrom. If they are sitting over your right, then that definitely they can. We can direct them. But if your right is not there, then how can we direct them?
because the losses kind is the agreement losses for 5 years losses. Losses pays 40 losses kind of
1-4.
yes, sir.
Yes, sir.
The lessons hereby dismiss the lessons been lent now this middle of the paragraph.
Yes.
The said dismissed pieces are lent
Demise piece of land shall be held by the lessee for a term of 5 years.
losses.
That's all.
5 years from the
There is a provision for an extension or a renewal.
because that is in the meantime losses taken by the from Tahsildar to the mining operator, the mine shell operators. So due to non-availability of the pollution control measures, they not allowed me for 1 year. That's why I claim losses. But limited losses, my
You can't do it. You have to show us that you have knowledge.
that's why I claim losses. Then like I consider my dependence and if this people are come before.
I have a strongest of reservation. If you have a legally enforceable right, they are sitting over your right, we will direct them. But in that event, you show us.
Loss in the next losses.
That is what always, when I put a question, it is always
In that
augmenting
document,
the adjournment.
in that document, they have admitted at page 28 that he failed to obtain the EC and other documents in relevant time. Let's see page 28, annexure 4 towards the middle. I could not operate the sand quarry for 1 year, that is for the year 2022-23, since I could not avail the environment clearance and consent to operate.
No, sir.
Losses kind of see only one prayer loss. Paragraph page 8, paragraph 7 losses. That's the petitioner has been granted is for a period of 5 years since the petitioner could not operate the said quarry for the year 2022-23. Therefore, petitioner is under a legitimate expectation that the petitioner will be allowed to operate the said quarry for another year like 25-26 in lieu of 22-23. By not passing any order in the representation petitioners, the deputy mines has committed illegality. That is pending before them. So they like to consider
When you made the representation,
losses kindly say
when you made the representation,
I have given on 4/9/25 losses.
24.
Page 28.
When you leave that spot. November.
Just
And when you
yesterday my loss they completed mine. Yesterday my lease was complete.
When is the application?
I losses kindly see page 28 and unestablished 4 losses. I given on 4/9/20.
Yes.
That let's consider that is sole player, my lord, nothing more, my lord.
The instant repetition is that the B has
That the petitioner arranged for payment of his legitimate dues, the supply of air, cables and water purifiers.
where is the player?
Page 11.
Can you maintain a repetition? Simplicity for the
Even as the tender was issued by the government.
keep it tomorrow. Keep it tomorrow and fix
Two matters.
yes, there are.
Item 12.
Second round before your lordship, my lord. The fact remains, my lord. The petition of rate of quarry permit for ordinary ad, lifting of ordinary ad for the public purpose, that is the repairing of the railway track, my lord. For that reason, annexure 1 was filed. It has not this unable to give direction within 1 month for application to be considered. But he has not considered. Annexure 9, I have filed contempt, my lord. So there is this honorable court in the preliminary for that he has violating the contract and notice has been issued. But under Annex 10, my lord, when the contempt is pending hurriedly, the opposite party number 3, Deputy Mines, dispose of my application with a view that the plot coming under the Pachiko deal. For that reason, I draw attention annexure 11. Annexure, that is the report of the DFO to the assistant conservator below. I draw attention annexure 11. That is page 32. With reference to the letter cited above on the caption subject is that the Deputy Director Mines insert Jaspur Circle request to verify the DLC over the khata number, plot number such and is it or any type forest area for ordinary earth to be used for railway project was published. In this context, a joint spot verification as a contractor
Demarcated protected forest. Demarcated protected forest. That is demarcated protected forest.
Relevant page is 33, finding of the DFO. Pachikot DFA under Jaspur Road range at 66.32 ha as mentioned in working plan of the division, the KMLC file of the DPF as received from ORSSE is of 667.32 ha. Notification declaring the extent of the land on the DPF boundary, declaring of DPF and perhaps a map is not found in the division as well as anywhere else in the record. This division has no such document with the proof that the area of the DPF is 667.32 ha except the working plan of the KMLC file. During FRJVC verification, the area of the DPF has been finalized as 215.76 ha as the location of the above plot is well outside boundary of the proposed Pachikot deal. This is the finding of the DFO. And for that reason, it also are given.
I'm appearing for the opposite party authorities. My lords may kindly see, my lord, this annexure 11 that my learned senior is citing.
This is subsequent to the rejection order. I have seen that.
My lords.
So once it is done, subsequent, then why is you will see that type over the. Yes, but it does not come under the DPA.
No, my lord, that is not what he says, my lord. My lord may kindly see page 34. My lord, this is a letter written by the DFO to the principal conservator.
True.
And my lord, the last 3 paragraphs, he asked for clarification from the principal conservator.
Because of the findings which he has.
Yes, my lord, there are some discrepancies.
Paragraph.
My lord, there are some discrepancies.
Therefore, has finalized this much of an area and it includes the location of his well outside the boundary. When he says so from the record that it is outside, come to clause 4 of the findings. So what does it mean?
No, my lord, sir. First, my lord, the first point of the findings, my lord. The first point number 1.
Forget about one. forget about file. If it is, you have rejected on the ground that it comes within the DPF area.
Yes, my lords.
And he says that this plot is outside the DPF area.
My lords,
Then he said that please clarify
my lords,
whether any permission can be granted or not.
my
How
lords.
can you sit over it?
No, my lords, we are not sitting. My lords, may see page 30. Page 30, my lord, the DFO has written to the Deputy Director Mines. And the last line, as per records, the working plan of Cuttack Forest Division, this said patch of land is coming under the demarcated protected forest. My lord, he writes.
But look at the subsequent finding of the divisional forest officer. He says that during FRJ VC verification, the area of the DFE has been finalized at 215.736 hectare. And the location of the above plot is well outside the boundary of the proposed Pachikuta DPL. Outside,
My lord,
not within.
no, my lords. My lords may see the entire page, my lord. Point number 1, the range officer Jajpur Road reported that. Point number 1. Although the above mentioned plots come inside the Pachikot DPF boundary, as per KML obtained from ORSAC,
Sir, why
my lord, they are
this
disputed. My lord, this is
finding
disputed,
is-
my lords.
say that the Pachikote DPL for the Jajpur Road range is 667.32 hectare as mentioned in the working plan of the division. The KML file of the city is received from such and such is of such and such hectare. Notification describing the extent of the DPF boundary, declaration and traverse map is not found in the division as anywhere in the record. The division has no such document with the proof of area is 667. And he says that as per FRJVC verification, the area is actually 250, not 667.
My lords.
And therefore, it is outside the boundary. And then he wanted, so which one is to be collected?
My lords, first thing, my lords, my lords may kindly come. My lord, this letter is of the
1st June.
June, my lord. July 7.
And then he's writing July.
Yeah, my lords, there are two different reports, my lord. One says it is within the forest area, one says it is not within the forest area.
Correct.
Therefore, my lord, the DFO writes.
Flagged an issue that I have
Yes.
gone through. I have gone through all the records.
My lord.
The way you are taking a stand of 667, I do not find any supporting document in support thereof.
No, my lord, documents are not there.
And say that I have consulted a document which is FRDVC
Yes, my lord.
and which says that the DPF is 215 hectare,
Yes, my lord. So
not 667 hectare.
it is disputed, my lord, and he is not clear. Therefore, my lord, in the
So
month
that
of
is why
July,
he wanted a clarification.
he wanted a clarification.
So what you are doing.
Thereafter, my lord, no, my lord, the clarification is there. My lord, this is in the month of July. There, my lord, at page 30, this is, my lord, on 30, my lord.
Huh?
This is, my lord, dated 24/9/2025. Here, my lord, the DFO writes on the basis of the clarification given by the
Okay.
principal conservator. Yes,
It was not placed.
yes, my lord. So here he writes that it comes within the protected forest area. And on the basis of this page 30, at page 29, which is the impugned order, my lord, the Deputy Director of Mines has rejected. But he has given him liberty.
But it's the same divisional forest officer.
Yes, my lord, Divisional Forest
No,
Officer,
different.
Cuttack Division.
Signature is, no, same.
Same, my lord, same, my lord.
Yes, if it comes within that, then how can we?
What happened? Basing of this report, he taken up this, how if this is the report, this is the proposed area is outside of that, and admittedly,
At home admitted. Where is an admission?
that is the annex of 11 million, that is the,
No, it's not an admission. He says that I have got this report, which says this much. But I find from verification, the area is this much. Please clarify what is the area. Now the clarification comes, yes, it comes within the purview. No.
because when the finding is so, I pray one thing, look, it is a coming under the, as under the provision of section 46, appeal will lie. So I permitted to file the appeal mirror.
So why you have done approach? Why you have approach? Withdraw it and go.
And because of he has not supplied the copy in the that is the provision, rejection order be supplied. As per the direction of the previous read, he has not supplied. I file contempt. against that contempt, he in 11/11 only copy has been supplied to me. Before that, only in WhatsApp they have supplied to me. That is the the contempt order below.
How could it be 11/11? If you have formed this affidavit on 7/11, how can you include the copy here? If it is supplied to you on 11/11, how can you include the copy of 11/11 in 7/11 writ petition?
But why they have supplied copy on the WhatsApp, not in a proper manner. For that reason, in 11/11, they have supplied copy in the content, the authenticated copy below. For that is the reason I could not able to file. So I pray only liberty may be granted for filing of the copy.
What is the if your right of appeal is not
Because of a delay is there, because of they have not supplied copy in a proper manner. For that is a certified copy has not given to me. For that is
where is the provision for an appeal?
that has
Under
been taken care in
46.
Yes,
Rule 46.
46 million.
You are within the period of limitation, why you are apprehended? It is a 1 month period from the date of the communication of the order. Communication was the order was on a WhatsApp.
They have, but that is not certified copy. I cannot file that copy.
Oh, then you have been supplied on 11/11.
Yeah.
You have been supplied the proper copy on 11/11.
Yes, on contempt.
You are within the period of limitation. Go there.
So for that, liberty will be granted for that.
No, sir.
Because they have taken that is the delay million for sure. Oh, I pay only that bill. Only. Because it is a it is not the it is a public purpose for the repairing of the railway track below. That is the reason.
Is there any power of conservation?
Not the
There is no power of conservation.
Section 35 million very specified for the purpose of public purpose. It is may be granted, and it is. Provided that no calibrate shall be granted to anybody other than the state agency or project proponent for public purpose. I am the it is for public purpose for repairing the track. During the rainy day, some disturbance is there.
There is no power. There is no power for conservation.
There is not.
Suppose one simply says 1 month. Then it says admitted, no official admitted under the amount as well as the then call for the records, see the proceedings. Is there any other policy?
Within 1 month.
My lord, there is a form X, my lord, form X, which reads, that is the form in which the appeal has to be. My lord, if my lord is holding this book, it is page 108. This book.
Oh. The reason for not resting with the prescribed. The order
fixed for disposal. Because of there is a necessity for the public purpose, for that is the reason. I mean, it's a
It's a very blunt example comes in my mind. Since we are live, I can't put it.
Item 13.
please don't. Limited point before your lordship, Manat. I was the highest bidder in Manat's 12 in the month of December 2020. I was given the tender for signed query. Now, after the getting the bid, Manat, I could not deposit the money as mandated under Rule 27, Sub-Rule 13, even during the within 3 months and even during the extended period mandated by the proviso within 3 months thereafter, 6 months. The reasons were, my mother fell seriously ill. She was admitted to the hospital. Day to day, I had to take over. Thereafter, my illness. And up to 2022 March, there was COVID. Immediately after the COVID, from 7 July 2022, I've been giving a representation every year. My latest representation is, the lordship may kindly turn to page 33. Said
kindly have a glance at page 32, Miller.
Just a minute.
He refused to.
Let me just complete my submission and Amit Flynn can have his say thereafter. I admit there has been delay on my part, my lord. The query has still not been tendered, auctioned, and my allotment has still not my lord, been cancelled. So I was praying, my lord, under 64, if the state government can relax, or if your lordship direct disposal of the representation as per their. They are still not cancelled, my lord. Option 6.
64.
64. 2016 rules. 64. This is the latest amendment 2025. This provision is there all through. In all the government may, in the interest of mineral development, relax. My allotment has also not been cancelled. They have not even withdrawn it. I still hold that allotment stands. And it's still not
So
filled
now
up.
you are.
Your lordship
You
gives
do
me
not-
7 days.
By this letter, you do not want to continue. You
No, no,
want to
I-
withdraw.
Manas,
You wanted to withdraw.
I wanted, but Manas, I'm
But
recovered.
now you have changed your stand. Now you want to
I'm
continue.
recovered. Your lordship gives me 7 days and deposit the money. It's a question of depositing 11 lakhs and 74. Lordship gives me 7 days. I've taken specific instruction. I leave it to your lordship. Manas.
So this letter has come, you immediately says, yes, we have cancelled it.
Let's just kindly have a glance to Rule 9, Miller. Rule 9, Sub-Rule 3 and 4.
Whatever we understand is that when you not communicate.
Miller,
No revocation.
we received the copy on 20th, Miller. I have sought for instruction whether any communication was made to the petitioner with or not. Because Miller, if your lordship will go through the medical documents even. After 1 year, he slept over the matter for 1 year. Miller.
I admit all that. But they're still not cancelled and it's there.
Whether it is cancelled or not, let's say,
Specific, that's
3
the
days time I will
specific,
take instruction.
that is the specific averment in the representation, all the representations, right from 22 have been giving representations immediately after the COVID period was over. In each of the representation I have written to them, you have not yet retendered it, not even cancelled my allotment. I was only praying that you may restore me to the position. Let them.
It's like a mercy petition.
No, I will not.
Can it be done?
I was only invoking under.
You wanted a fresh lease of life.
No, now that the equity has not switched in anybody else's favor, I still continue to hold it. And within 7 days, my lord, I'll record my undertaking. Within 7 days, I'll deposit the money. It's a question of state revenue.
I have taken a view. Thank God.
They give it.
There is a legally enforceable right.
But I bow down, my lord.
It's not there. The petition.
My only submission is, my lord, they will get the same money from somebody else. Why not take it from me?
Not same money, maybe a higher.
Maybe a higher money. I don't deny that, but they have still not cancelled my allotment. My allotment has not been cancelled.
Taken instruction. Yes. On Wednesday.
Can be on Thursday, my lord. Thursday. I'm sorry. Your lordship will call it on Wednesday. I'm sorry, Mr. Lordship will call it.
Oh, sure. When these category of matters are there.
Next Monday.
Next Monday. You come on next Monday. Yes.
Beautiful.
Yes.
Let my learned friend also take instructions in the meantime.
Yes.
Item 14.
Yes.
14, my next.
Late leaders.
Your lordship, little different from other matters, lordship. Here, lordship, I have been restrained to offer it due to pendency of the litigation, lordship, before NGT, and state lordship kindly come to Annexure 7, lordship, for a moment, page 39. Lordship, here, lordship, because of pendency of the case for the NGT and interim order, I could not operate during the. I've been restrained, lordship. So, lordship, here perhaps it's a covered matter. Lordship, can you say I've quoted the similar cases when dealt with by this honorable court. And lordship, state I have come to lordship. That is, I have quoted the entire order. And it appears page 15.
Now, what happened? NGT has subsequently withdrawn this one.
Lordship, now, lordship, that is been.
Where is the one?
Lordship, that is not available with me. They have never communicated to me. Lordship,
You have to show.
Lordship, only I have come to court. Lordship, I will produce that order because that is not available. I have tried to get that order, Lordship.
So, though it was for a limited period.
Lordship. Lordship, it's Lordship shows Lordship. I just yesterday I have to verify. Since 21, it has been disposed of, showing disposed of without any order.
So that it is disposed of.
Lordship, I see. Lordship.
What is the order you have?
Lordship, order that is not available.
Next one.
Lordship, that's it.
Item
15. May I please your lordship, my lord? I am a virtual court at Puri, my lord. My response submission before your lordship. Here the annexure 4 running page 44 is impugned and passed by the collector from district magistrate Khorda, my lord. Because, my lord, this is being the second round litigation, I humbly submit before your lordship that please make a glance to the annexure 5, my lord. As for the annexure 5, my lord, guide page 41 and the operative portion is, my lord, that is the 44. As for paragraph 4, your lordship was also disposed of the read, my lord, towards a disposal of the represent.
Where is the order dated 23/9/2025?
My lord. The earlier read order was 18 March.
I am asking you, sir, where you wanted to quash order dated 23/9.
My lord, annexure 4 running page 44.
40?
Annexure 4 running page 44, my lord.
Yes.
This is order passed by the collector Khorda, my lord. The case is like this, my lord.
Just 1 minute. What is the reason for withdrawal?
My lord, the reason behind it, there was a earlier writ application filed by another person by annexer 4.
Where is the reason?
45.
Reason they have, the collector has only referred to the judgment passed by the honorable court, where the competency of the sub-collector to execute a lease on behalf of the Sri Jagannath Temple, Puri, after the commencement of the new rules under the OMMC rule. That was the subject matter in the writ petition, where the temple administration considered to the extent that order is there also. My learned friend has enclosed Satya Pir Sri Chandra at page 48, where the temple administration also considered that they don't have the authority, and it is only after the amendment the Tahsildar is the competent authority. This is prior to 2022, and after 2022 amendment came into force, it is only the mining officer. But here the lease deed has been executed by the sub-collector on behalf of the temple administration, because the property belongs to the temple administration. But however, my lord, under the rules, be it pre-amended or post-amendment rule, OMMC rule, the competent authority has been prescribed. Either it is the Tahsildar or it is only the mining officer. And so far as administration,
Sir, there are two aspects. I think earlier in some of the matters I have flagged certain issues.
yes, your lordship have issued notice to the temple administration.
Correct. I have flagged an issue because this particular, there is a special act concerning Lord Jagannath temple properties or the administration. What is that act?
Sri Jagannath Temple Act 1955.
Correct. So this is a special act
Yes.
which is promulgated. Now, whether the subordinate legislation, if it runs in conflict with the substantive law, which will prevail, it's a substantive act or the subordinate legislation.
Is the act which will prevail.
If the mining act, which gives the rule-making power, from there this concession
The
rules
act
come.
which is a central statute.
Central statute. Now, when there is a central statute and when there is a special state act, and if both are not in conflict, then if they come under any of the entries of the seventh schedule pertaining to state list, which should prevail? Special act or the central general act?
The central statute will prevail to the extent it is repugnant in terms of 254 of the Constitution of India. But here.
No, I understand what you are saying. It is not that I do not understand. But again, I am saying, if the state is empowered for a specified purposes or for a specific thing, then in that event, the general act and the special act.
The special act will be. Special act will be.
And how the concession rules, all these things you are bringing in.
But the concession rule, by answer.
But again, I am issuing whether he may be a owner of the peripheral surface. Can any owner of the land have a vested right or a legal right to a natural resources beneath that surface? Or it is the government who owns?
It is only the state government.
So that is also one of the important.
But and in that case also, same issue was discussed, and your lordship have issued notice to the temple administration.
Tag it with this. Tag it with this matter.
The same level, 97.
97.
Item number 16.
Whole India scheme. Whole is shown on the basis of its grade. Grade is determine the price, usability, and industrial suitability. The grade is determined by the colliery control rules. I have annexed that at, I'm not sure, 5 series. It is determined under
What is, which page you are referring?
I'm referring to page number 122.
Say that because I am holding a brief which does not have I was the flag of on the basis of the annexures. Page 1.
22, 28, exact page is 120.
Yes.
And the procedure for categorization of coal.
Yes.
The-
Yes. Yes.
This is how the coal is categorized. The coal has to be, the owner or the manager of the coal colliery shall declare the classes and grades and sizes of the coal that is to be used in a seal section of in accordance with the procedure specified in sub-rule 1. Sub-rule 1,
Is method of sampling and analysis of the coal
Exactly.
for declaration and maintenance of the grade.
Yes, ma'am. The
So-
central government declares certain grades of the coal. A particular seal is having a particular coal that has to be determined by the manager of the colliery. And the same has to be inspected by a coal company. Thereafter, the coal grade of a particular seam of coal is determined. And accordingly, the auction is fixed. The central government has page number 117.
Yes.
After undertaking the process that under the colliery control rules, they are given an offer for auction. The grade of the coal is here G13. There are 17 grades of coal. One of the grade is G13. They have categorized representative grade of the coal is G13. They have reserve price of the coal is 1013. So this is the offer.
Yes.
Now let me see. Any interested bidder by registering in the MSTC portal may participate in the auction process based and then bid on the offer that has been given by them. Now, my lords, there is one clause that we are challenging, that is at page number 43. 5.2, determination of coal supply price.
Yes.
My lords, we see clause of that.
Yes.
Although the auction will be held on the representative grade and size, the successful bidder shall be bound to accept coal for any grade and size from the allotted siding in case of a rail dispatch. They are saying that it might not be see 5.2b.
No. What is the tender for?
No, my lords, it's a e-auction of coal.
E-auction of?
Coal, my lords.
Correct.
So, anybody.
So in the auction, you will purchase it, and the yes, when they have issued this particular you just drew our attention to that page.
Yes, ma'am. That is the course of e-auction scheme. That starts at page 36. That is CIL e-auction. It is through this scheme that they are conducting the auction, and anybody interested to participate has to abide by the terms.
Yes.
My case is that they are offering a particular grade. I am bidding on that particular grade, but at the end, they are saying although the auction will be
No, I understand. You may be supplied of any grade.
any grade. And then, not only that, they are saying that even they are taking a security deposit in the form of bank guarantee. That is, they are calling that a financial coverage. That irrespective of fact whether I am bidding for grade 13 of coal, I have to give a financial coverage of 2 grades higher.
Where is that?
That is at 11.8.3. That is page 52, my lord.
Yes. When the tender is going to be opened?
Minutes, on the next date is 20. Okay, last date for auction is tomorrow. Participate in auctions. This is for the month of November. The last date for that is at page number 112. The last date of application for.
Oh, where it says that the guarantee which you have to submit is twice.
It's not 2 times higher grade, not twice.
Yes. 2 times higher grade where?
That is at
It is not page 52.
52 is there. Then my lords, since MCL is conducting this, so there is a.
That's the equivalent, 100% equivalent value. Not 2 times higher. I mean 2 degree higher.
2 degree, my lords, it is equivalent to 2 grades higher.
Where? I do not find that.
That is, my lord, at page number 70, annex 2.
70.
Yes, ma'am.
Yes.
That's fine.
So this is something, if you ask for a third-party sampling, they have already tested it and they have identified the grade. And this is what 11.8.3 says. It's an option to the bidder. If the bidder wants that the sampling has to be done by a third party, then he can do it at his risk. Once an option is given, then you have to deposit that. If suppose if it is of a higher grade, then you'll have to.
We have to deposit it if we choose the third party sampling. But
Correct. That is what is the option. Is the option means an alternative. If you chose not, you're not supposed.
But I have a right.
Sir, you can't put them. You have a right. Then you can definitely. If something comes higher, then it's not of a grade 13, but it's a grade 14.
I should be given an opportunity to say no. But they are saying.
So they say no. They will not insist. It is only in that event because 11.8.3 talks about buyers opting for third-party sampling can avail such facilities in the following manner. And then this letter has to say, as per the letter scheme documents, as per clause 11.83, any coal dispatch from such and such will have to mandatorily provide financial coverage towards upgradation of coal arising out of a third-party sampling. If it is not a third-party sampling, then
they are saying that I have to take any grade.
no. This is very, very clear. It's an option. You can't. It is up to you whether to choose or not to choose.
Even if I don't use my lord, and I opt for not to take it, they'll forfeit my security.
No, this ground I do not find is correct. The first one I can understand that they wanted that though you are the bidding for a particular grade, but the dispatch can be of any grade. That is illogical. Who is for this coal? Who is auctioning? Who is auctioning?
Coal is a separate panel. Only Union of India we are attending, Mr.
Opposite party number one, I am depending on.
Opposite party number one means?
Ministry of Post.
We don't have any role, my lord.
Yes, Ministry of Law. We wanted you, sir.
But
You are representing Coal India Limited.
no, Coal India Limited is different. They have different panel council they are paying.
How can it be done? If you have segregated a grade of a coal and you have said that grade 13, grade 14, that is all, and separate auction is there for a particular grade, then how can you put that even if you bid for grade 13, you may be supplied grade 10, grade 14, grade 16? How? You have been doing all this sampling before the auction is held. That is what the modalities have been provided. And how it is done? That although the auction will be held on the representative on the representative grade and size, the successful bidder can be bound to accept the coal of any grade and size. What is this? Page 43.
Yes.
Clause E.
Prior to that, the post e-auction process.
That is what is there. There is already a process for testing.
Yes.
Before it is put to auction. And you have now chosen that this is what the grade comes. What more? An option is that if he is not agreeing, he says, no, it is not grade 13 which is supplied to me, it is grade 1 or lower grade. Let us see, not a upper grade. He can go for a third party testing. And if it appears that it is of a higher grade, then he'll have to pay the amount.
But the type BC, in case stream or slack, coal is allotted for the auctions. Tell the representative size of the coal, the 0% premium derived will also be applicable for over the price differential between representative size and systems slab coal, as a case may be.
But so far as the grade is concerned, you can't. Grade is concerned, you can't.
It is unknown to everybody.
That is really, no, I understand. That is why when you put a particular coal on an auction, is being mined constantly. Now, I think what you are auctioning is already a mined coke which is stacked there. You must have taken a sample and then testing. You say that this contains grade 13. If he is not agreeing, he says, no, it's not a grade 13, it is inferior. You are supplying me inferior. Then he can go for a third party testing. Once he go for a third party testing and it appears that it was grade 9, not 13, for which he has paid the amount, then you are bound by it. And there is, suppose it may so happen that instead of 13, it comes to 15, upper grade.
Yes.
Then he has to pay the difference. He has to pay the difference. Now, how can it be done? This can't be done. Huh? Notice. This cannot, you cannot continue in this fashion. Have you applied or not applied?
Union of CGC is along with CGC. One.
It is senior notice.
Then notice.
Internal. You take notice on that also.
Notice on IA, let them just put the auction there for the time being. And we are keeping this matter in the next week. So they cannot finalize in the meantime. We'll do it, whatever. Next, first. Huh?
Isn't the trade finish look at all? In the face segments and.
You can furnish in speed post by tomorrow and email also.
Also, email.
In addition, email service is also.
Yes.
File affidavit, email.
Oh.
Both.
What matter? Huh? Huh? What is that? Item? Call?
Matter fixed for 2 p.m. hearing, item 39. Sir.
Here as well. But AG was supposed to appear. He's not available. Can I pray next week, any day, or if my learned senior continues his argument today, we can reply some other day.
I think this matter was already directed earlier, way back in the month of October, sir.
Well,
15th of October.
the amendment was carried out on.
But there was a direction.
Yes, only.
This is not expected.
Major mineral.
No. Is there any emergency situation? I can understand, but the matter when it was fixed, this is not expected when it was fixed in presence of all the parties and that too 1 month before. So somebody has to adjust his.
Let my learned senior continue.
But again, the same thing is the continuity is lost. If we hear out in a piecemeal manner, then who will be responsible? It's a sheer wastage of time that I will hear without any disposal. There are many matters which can be disposed of in the meantime. This is not expected. We'll grant you adjournment, pay the other side the actual cost which he has suffered for adjournment today. We'll give it. Don't worry.
Give it to B, that's all. You can't pick and choose. It's a very narrow perspective. So I'm not going to trouble.
So is an act of discrimination.
That's all.
My learned senior start his argument.
What?
I'll answer on Wednesday. On Wednesday, I'll answer.
No, we can't dictate. That the member of the bar will dictate how the roster is to be adjusted by the bench.
I'm only making the.
No, sir, you can't. No, this time now I am becoming. Monday is a matter for mining days. Tell me.
Monday.
Either you argue or somebody else. You have to find out a substitute.
Fine.
Find out a substitute. What can be done, sir? The situation is such.
Your lordships have read the file and come. Your lordships.
No.
Your lordships.
That is a different.
Predicament is worse than mine.
No.
This is our.
Today's scenario is different.
Our job.
Today's scenario is different. I have not burned my midnight oil. So, reach the station very late in the night. So, there is no difficulty. Monday?
Very well. Would your lordship be considered Monday 2 p.m.? Is that convenient? 2 p.m. on Monday would be convenient?
Yes. You have seen the convenience and the fallout of the convenience.
At least the learned AG can then manage his time and not be caught in some other court. You can give us half an hour, it won't take more than an hour.
Monday.
Well, an accommodation is sought
This method comes under the Sri Jagannath Temple Act. This method comes under the Sri Jagannath Temple Act 1955 relating to liberation of its members so far as Sabaka Goshti group is concerned under section 6(1)(j) of the Act.
What?
No,
I understand. What is the problem? Is relating to any mines, minerals, Shiva.
Let me let's from the background of the case. But here the case, my lord, there are 119 categories of Sabaka published in the Odisha Gazette. And
What you wanted to set aside the guideline of 1812 and also the judgment of 39.
My lord, the judgment passed by the Honorable Senator on 3/9/20.
Oh, this is sorry. I was thinking of
I am challenging the judgment.
Yes.
3/9/20.
I was thinking it is a writ petition. That's why. No.
Honorable
Where is the judgment?
My lord, the annex to 12 you lordship may kindly see page 42.
Starts from page 54.
52.
Yes.
Page 52.
Page 54, it's done.
Just 1 minute. Can you give me 30 seconds so that I can hurriedly go through this? So now the managing committee is empowered.
But the dispute is
He
not
says that
related-
since the managing committee has come, you can ventilate your grievance before the managing committee.
No, my lord. I'm not explaining before. Lord. I have filed a writ application stating that as there is no provision under the act as to the manner and the process of selection for recommending the names of the Seva to the state government. The law says, their provision says, Lord Jagannath Temple, that out of Seva, 5% will be nominated by the state government out of the panel recommended by the chief administrator of the temple. There's twice the number required. That means 10 numbers of Seva merit will be recommended by the chief administrator to the state government for to nominate them as a member of the.
Why the chief administrator has been appointed?
Well, chief administrator is the senior.
Is it a stopgap
No.
measure or regular?
Permanent, regular.
Regular.
After the Supreme Court judgment, now it is a regular.
What is the utility of the managing committee?
Managing the state government is the supreme authority of the Sri Jagannath Temple, but the powers of the state government vested with the managing committee to look after the day-to-day affairs of the temple and its governance and the properties and endowment of the Lord Jagannath. Therefore, the managing committee discharges a very powerful function so far as the Lord Jagannath Temple is concerned. There are 119 categories of Sevas as per the notification under the Act.
Now, with this guideline is issued by whom?
But a guideline is one of the Honorable Single Judge after satisfying that.
No, don't. I looked at it because you are also challenging a guideline. That's why I'm saying who has framed the guideline.
But pursuant to the direction of the Honorable Single Judge to the state government,
Yes.
because there is some illegality and irregularity committed while recommending the names of Sevas, and you prepare a guideline. frame a guidelines and submit before this court.
Correct.
The state government furnish a guideline.
Correct.
Therefore, after furnishing the first guidelines, they withdrawn that. They said that it is contrary to the provision, therefore we may be permitted to withdraw. It is withdrawn. Subsequently, again another guidelines was put. These guidelines also contrary to the provision. Because how many numbers from the Syriac group will be recommended is completely silent. And these guidelines were neither approved by the.
So it is silent.
Yes.
But so far as the act is concerned, the act provides how many?
Act provides the 10 numbers of Syriac.
True. So how can they say if suppose a guideline does not speak of the number of the persons to be recommended or nominated, then naturally what is not provided in the guidelines will be guided by the act. Or even if the guideline provides something else, it cannot receive a judicial sanction because it is contrary to the act. So how you are agree by that?
6 numbers of guidelines were fixed.
Correct.
6 numbers.
Correct.
One is, this guidelines is nothing but like the old fashion. According to these guidelines.
So that if there is already I think the centuries old prevalent traditions, would you like that overnight it should be completely changed?
My respectful submission before your lordship that repeatedly a specific group of the Sabbath has been representing as a member to the.
So that is what
and
you
there is a successive omission of the other Sabbath group. Because there is no provision. When we approached the Honorable Court first writ application directed, you filed a comprehensive representation before the Chief Administrator and you will found the reason order. He stated that this is my discretional power because of in the absence of provision that cannot be questioned. That was challenged in the Annex 7 in the writ application, the prayer, the lordship.
Who says is my absolute discretion?
The Chief Administrator.
Where is that order?
That order, my lord, your lordship will kindly see. Annex 13, page 57. The last paragraph, page 57, it will start from there.
Yes.
In obedience to.
Just 1 minute. Where is the act? Where is the act?
The lordship may kindly see the section 5. Section 6 is the
procedure, how many members will be, the managing committee will be constituted 12 members, composing 12 members. The other members are the senior officers of the state army, are the ex officio members, and 5% from the Sarai, and one from Muktimadam and one from Mat. Section 6, the procedure. And tenure is 3 years. I am concerned with the date.
Yes. Oh,
Madam. For last decade of years, I have also annexed the documents.
so you belong to a particular category of the Sevaks.
Yes.
Now, it does not make any distinctions. It simply talks about these out of the Sevaks of the temple. So collectively, the 5 names have to be given. And proviso says that for each category of I, J, and K, at least twice the number of the names to be provided by the administrator, chief administrator. Now the question is that when you are coming before us, tell us from the historical view that this kind of a committee previously constituted, contained everything, or there is only one class of the category of the Sevaks. Sevaks constitute a specific class.
Repeated.
It's a homogeneous class itself. Is there any distinction amongst the Sevaks?
No.
So it's a homogeneous class. In the homogeneous class, you cannot say that I have a right to represent in the committee. You can't say. It is how they will assess on the basis of one's performance, one's, the many factors. I do not want to say anything. So what?
But the discretional power exercised by the chief administrator,
Yes.
as for his satisfaction, cannot be ignored the adjudicating fact the Sevak those were every day engaged to perform the Lord Jagannath Niti Kanti, the traditional Niti Kanti.
Correct.
But there are 119 categories of Sevaka. Daily requirement of the Seva Puja is 90 times, 90 times. And out of that, these particular Nijogo, there are so many, and some other Nijogo, the Nijogo is the association of Sevaka, and it is called Nijogo. This Nijogo, confederation of Nijogo is called Satisha Nijogo, according to the record of rights of the Temple Act. But here, particularly a specific group, Daitapati, Pratihari, Suara, Mahasuara, there are different kind of categories of Sevakas.
Sir, I asked you a very first questions.
Yes, Madam.
Are there different categories of the Sevaks? You say no, Sevaks are one.
No. Different.
So I say they constitute a homogeneous class. You cannot say that I should be picked up.
119 categories of Sevaka are there.
Have you made out a case that since the advent of this committee, constitution or the law, only one category or two category of the Sevaks are incorporated, the others have been left?
from one Sevako group, 5 names recommended. When the 10 numbers of members is required to recommend, they pick up the one category, 5 names. They pick up 3 names in one category. Other Nijoko successively ignore matter. For decade of years, that is
Because
why
in
spirit of
the
deviation.
position, the difficulty is there are numbers are very limited. The numbers are 5. You say that there are different categories of the Shivaks which are more than 100. Now you tell me how one category or 2 categories can be taken into account. There should be some. How can it be? All 100 and more than 180, what do you say, 180?
190.
100?
19.
119. So how 119 categories, one representation, how he can make? He has to filter out. He has to eradicate some categories.
But sometimes some terms will come without, for last repeatedly, I have annexed the documents also for the year 2011, 14, 18 and 21. Repeatedly from 5 groups. And this year is also the same group. It's the old fashion. What is the meaning of guidelines? These guidelines also not verified, not
Who is representing? Who is representing the Jagannath temple?
Notice has to be issued.
Notice.
What?
3 weeks.
Weeks. Have some.
There should be some mechanism. By periodical way.
Dispute is not with regard to the constitution of the managing committee.
Sir, I understood, sir.
Honorable Singh,
So what do you think? Why we are giving a notice? Otherwise, we'd have rejected it. We issued a notice for some reasons. So, file the requisites. 3 weeks, matter will appear.
Item 18.
18 I have filed an IA, that is IA number 4540 today itself, madam. Because one of the prayer of the deed of will has been wrongly typed the prayer of the retreat. That is why I have filed an IA today, that is 4540. Your Lordship,
For what?
For amendment of the prayer. Your Lordship, kindly take up along with that IA, madam.
Where is IA? Let it be listed. Adjourn for a week.
So 19.
What is this? Who is for the other side?
But here actually, central government is there.
Why the matter is division bench? It was listed before the single bench. Why it is listed here? Why it is listed? I find the last order of 13/12/24 says that this matter does not pertain to the assignment, so let it be before the other bench. Then why it has come to the division bench? What is this? Huh? What flag is? That's an additional affidavit. That's additional affidavit, sir. Huh?
Next.
Oh, there is an order. How it pertains to this?
Annual trade, you go to single bench or Indian, then you have.
There is confusion.
There is no tender matter. This is simplistic case of challenging the debit note.
Not a tender.
So this was a wrong impression which is given.
No, capital account. Tender.
It says.
I think number 20, filing counter in the course of the day, my lords.
Will be filing or filed?
Will be filing in the course of the day, my lords.
It will not be properly.
I did file it. So
It has not taken birth as yet.
just finalized, my lords.
Record the name, submits that the counter affidavit is otherwise
expected to fill an affidavit.
Counter affidavit is a affidavit, sir. Don't.
Item number 21.
Matter, page was not there, my lord, has come now. This is a matter where my lord have issued notice and indemnity of action. These are the orders, my lord. This is where the new lessee is not permitted to mine, win the mines, and an impost has been made.
But here the virus of 12A.
Yes.
That match of matter, those matters have been posted. Third of December.
3rd December.
Same matter.
Same order passed.
For sale. You have got the order or not order? Is there any interim order in your case?
Interim order has been passed.
Here the demand notice was issued in month of September.
Yes.
Same. That is not to do that.
Yes.
Previous two applications to be tagged on with this similar matter.
The difficulty is I am totally against the tagging of the matter.
Okay, very good.
So don't tag it. Only thing is it should be listed on that day. Multiple arguments is a difficult task.
Absolutely.
Yes.
Item number 22.
But
74. Copy not served. Serve the copy. Next. Next copy has been served in course of this day in open court. Next week. Take instruction.
Item 24.
We will not grant any adjournment because you are adjourning for a week. You have to come with the instructions.
Last time also you have not served the copy and to
No, what I am saying is that this adjournment scenario, that should not be there. You, in the meantime, secure. Yes.
Item 24.
Petitioner in this with application, challenges the appeal order of the commissioner passed under the CSP Act. The facts of this case, my lord.
Yes.
The facts of this case, my lord, is that this particular petitioner effected branch transfers by virtue of F forms. Initially, my lord, the provisional assessment under section 12(1) of the CSP rules was accepted. Thereafter, my lord,
The revisional order is under, and the appellate order.
month.
The revisional and the appellate order, both are under challenge.
Under challenge.
You filed an appeal against the revisional order. Now,
Again, come up in the writ petition because
Correct.
there's no other forum before.
Correct.
My lordship.
Now,
The facts of this case, my lord, is initially the
why
petitioner.
don't you go some other forum?
It can't, my lord. As per 79 of the OVAT Act, my lord,
Huh?
if the subordinate officer to the commissioner passes a suo motu revision, the appeal lies to the commissioner.
Correct.
And thereafter nothing.
Is silent.
That's fine. That's section 79 of the
No,
OVAT.
there, in Bengal is a different. In Bengal is a different. That's why I'm asking.
No, if commissioner versus.
Then
High Court.
Then High Court, I understand.
So,
So why directly to the division bench? Because of the category of the matter, tax.
It's a tax matter.
In our taxation. Single bench.
If your lordship would create a category, create a forum for us also.
No, I am more accustomed there. It's a single bench.
Here we have a division bench for taxes.
I think bar has been agitating since long. For a single bench, at the
So there's
initial
a
stage,
appeal
they
like
have
your
to
lordship's
appeal
bench.
before the division.
No.
Since 15 years I have been.
So what has happened, my lord, initially this particular petitioner was.
Where is the order?
So the order, my lord, is at Annex 1, my lord, at page 45C.
That's the appellate.
That's the appellate order. And so far as the revisional order is concerned,
No, I just want it.
May I just place the facts so that your lordship will be in a position to.
Yes, go on.
Here initially the petitioner was provisionally assessed under section 12, rule 12(1) of the CSTO rules, and all my F terms, which is necessary for branch transfers, were accepted. Then alleging that there has been under assessment by virtue of an AG audit report, proceeding under the rule 12(4) of the CSTO rules was taken. That was dropped because it was barred by limitation. Because the assessment year, my lord, is 13-14, and the limitation of 5 years from 13-14 stops at 2019. So they could not have initiated a proceeding in September 2020. So this particular proceeding of underassessment was dropped by the sales tax officer. While dropping it, my lord, he says that please initiate a suo motu proceeding, and he transfers the file, my lord, to the joint commissioner. My lord. The joint commissioner, in his turn, he recommends that this suo motu proceeding has to be initiated, and he transfers the files to the additional commissioner. The additional commissioner, my lord, he initiates the proceedings, issues notice, then he sits, and we give a reply. He stays quiet, my lord. All of a sudden, my lords, we receive a show cause notice from the joint commissioner. After receipt of the show cause notice, my lord, we file for certified copies, and from the certified copies, it emanates that the joint commissioner has given a note that all orders passed by the sales tax officers can only be revised suo motu by the joint commissioner. And that's how I am initiating the proceeding. My first humble submission would be, my lords, 79, my lord, begins is a suo motu power. It cannot be at the dictates or prompting of authority. It can be done, my lord. So here, my lord, your lordship, I'll take your lordship to the certified copy.
According to you, this provisions that so far as the initiation at the why the period of limitation was provided?
The period of
provided for.
So far, under assessment is concerned, they began by assessing me for under assessment under Rule 12 of the CSTO rules,
Correct.
basing on the AG audit objection.
True.
When I objected that for 13-14, this lapses, 5 years lapses, not 5 years from the end of the assessment.
So now there is no limitation period for suo motu.
No, when this was dropped, the suo motu power was from the 5 years from the end of the order.
Okay.
So that was there. My content.
Suo motu power to revise.
Revise was there.
What, revise what?
Revise the order of assessment.
Order of assessment was subsequently found to be wrong, or there were under assessment or something of that.
An objection was raised in the audit that it was under assessed.
Under assessed.
The under assessment proceeding was initiated.
Correct. I understand. That means the order of assessment was really a subject matter there.
Manus.
That whether this assessment order is correct or not.
Manus.
And thereafter they say barred by limitation, it has to be dropped.
Drops it. And while dropping it, he says, please initiate suo motu proceeding, and he sends the file to the joint commissioner.
Against the assessment order.
Against the assessment order. The joint commissioner in his turn.
No, I understand. I am just saying. This is what.
Sir, the judgments of action bench finalized saying that from the end of the assessment year, entire proceeding of suo motu, I think, has to be completed within 5 years, not beyond time. So here,
show me the provision of the act.
Date of order is 21/12/2023.
That is not just
suo motu reason.
No, I'm talking. No, I'm talking about
order. The revision order is passed on 21/12/2023. The period of assessment.
No, not GST. This is under the old act. This is under the Sales Tax Act or VAT?
That's the Sales Tax Act and the OVAT Act.
CST and when was
the original assessment order is page 63 minutes. That is date minutes 29th of December 2018. Annexure 3 at page 63. So from 18 he gets 5 years.
5 years.
So that is how that initiation is correct.
No,
The
audit visit report itself was time barred. And we could not have initiated 42 proceedings. Then subsequently by dint of appellate order 49(2) cannot be initiated. So that was the.
I have yet to not read your lawsuit order. I'm aware of the lawsuit.
So my approach was our approach was when initial assessment itself was time barred.
No, this is what that really troubles us. There's interesting questions. The original assessment order could not be interfered because there is already a timeline which is given has expired.
For under assessment.
Whatever under assessment is expired. Now, taking a circuitous route, you wanted to reopen the entire issue because the law is there and you wanted to do it. This cannot be done because if you adopt this kind of a things, then
there'll be no blocks.
No, there will be no. After 30 years or 40 years, one will come.
And secondly,
another aspect.
No.
Honorable Supreme Court judgment.
What do you say?
For 6A.
Who?
I'm sorry, Your Lordship, I am appearing on BC, Your Lordship. I am suffering from fever and back pain, Your Lordship. This case, Your Lordship, I'll file a detailed counter in this case.
What detailed counter you will file? This is a pure question of law. What detailed counter?
Your Lordship,
there was already an assessment order.
Your Lordship,
that assessment proceeding was initiated,
Your Lordship,
apparently barred by law, and this authority has recommended for suo motu. This is really.
That is not the case, Your Lordship.
It's not a case.
Your Lordship, there are two types of.
It's not. Then where is the observation? The suo motu.
66. Page 66.
If it is not a case, then tell me what is the meaning of this.
Page 66.
Your Lordship, kindly for a moment. Your Lordship.
What is the meaning of this?
12.1. Your Lordship, 12.1 is provisional assessment. 12.4 is escaped assessment, Your Lordship.
Sir, I am understanding, sir. This case is satisfied in the order sheet earlier is now submitted for the information of the intimation to suo motu proceeding as per law. What is this? What authority has?
I wanted to file a counter, Your Lordship. Detailed
Counter. What you will say on a proposition? These documents you cannot deny that this order is not passed.
I have to take instruction from the department and I have to file a counter, Your Lordship. Your Lordship,
Earlier you said there is a limitation and
Your Lordship, please try to.
It is stated, it has not been disputed before us that all the requisite particulars have to be stated in format. Format is accepted.
Kindly admit and stay may be granted, Your Lordship.
Once a determination is made that such statements are correct, the curtain is drawn, keeping in view the expression thereupon. The said word is of great significance and must be given its full effect. Then their lordships have said, unless there is ingredient of fraud or manipulation or tampering or whatever of that sort, then only reassessment. Otherwise, F form cannot be reopened.
And interestingly, my lord, all these materials, the F forms along with the supporting waybills, are there, my lords, and I've given the lords the waybills and the F forms, my lords, as by way of an additional affidavit today.
Accepted. So
And the observation of both the three
allegation.
The allegation, my lord, is that one particular consignment which was sent to
That waybill are mismatching. The waybills are mismatching. The allegation is that.
Except for the F forms, the waybills, no supporting documents are there. I've given that additional affidavit, where all the waybills for 50 lakhs amount was very much there, you know. It is uploaded from, downloaded from their VATIS, you know. They can't say, wow, VATIS does not consist of these waybills. They say that out of 39 waybills, this particular waybill relatable to this F form was not there. It's not a fact, you know. And I've given to Milord to collected all the
case.
Your Lordship, actually, Your Lordship, try to understand, Your Lordship, my limitation. Your Lordship, I am appearing on behalf of the department. Let me take instruction.
Rule 22 of the CST
This
O rules.
Chapter 5 introduced in the year 2010.
Yes.
Then I.
Lordship, let it be taken on next week, your lordship. I may be, opportunity may be granted to me, your lordship. Let it be taken on next week.
Come ready. Is there any demand which is there?
Your lordship may kindly stay the demand. Your lordship may admit and file counter. Your lordship, try to understand my limitation, your lordship.
Now attach my bank account, and I've given additional affidavit stating that.
Your lordship, I may be permitted to file counter, your lordship, in this case, your.
This has made this amendment.
Innocent.
It all emanated from Ashok Leyland, 136 STC. I think 136 STC, that's Supreme Court, under Supreme Court in 2004. So then this chapter, this section 8A was introduced. The highest authority in the state, they are in session of section 6A disputes. So F1 cannot be rejected. Once it is accepted. I don't examine it. You don't have the power to do that. Once as Parliament has passed a separate set of provisions for dealing with such a situation.
Your lordship.
Under
Your lordship, only my limitation, only my prayer is to grant one opportunity, your lordship. Let me take instruction, file a small counter, your lordship, may dispose of the matter. Your lordship, because your lordship's only.
that again, Mr. Again, we are falling into that trap.
Sometimes.
Initial assessment itself was bad. You have dropped that procedure.
No, your lordship, the original 12-1 assessment has been, your lordship, Somoto revision. The Somoto revision has been made done against the 12-1 assessment.
You have to show both twin condition is.
Your lordship,
Unless you are.
What is this? What he is referring? Which provision? What provision is he is referring?
12, the original assessment which has been made under section 12-1.
12-1.
Your lordship, that was
Rule 12-1.
Rule 12-1.
Rule 12-1. That was the subject matter of Somoto revision, your lordship. Admittedly,
CST, what rule?
CST Odisha rules, your lordship.
Where is that? Yes.
That was well within the time. Only the department has initiated rule 12.
Just 1 minute.
Your lordship, which was time barred.
Not sure get 12-1 at a footnote. This was amended with effect from 1/10/2015. The footnote. This is prior to that. Prior to that. It's 12-13.
Your lordship, multiple issues have been raised. Your lordship may admit the matter. Because some factual aspects are also there.
At the relevant point of time, this was the rule. Subsequently, in 2015, there was an amendment. So that was the entire thing is changed. So this one is.
That is what I'm reading at. I'm reading at. 4-8.
One is, your lordship, just like self-assessment, your lordship, only if it is
the only forms are to be verified, Your Lordship, in lieu of the return. Subsequently, scrutiny, Your Lordship.
Clause E is the important. That's a 5 years period.
5 years period is, Your Lordship.
From the end of the period in respect to which the tax is assessable.
So in the 13-14.
13-14. So 2019 it is
So
over.
19 March.
So they initiated proceeding in September 2020. Then they dropped it because
No. 21, that is 12-4 proceeding. 12-1, 12.
If that is barred, then how can you develop your case?
So
But
much
let us see that whether yes, let come ready. I think one has to ponder upon.
Your Lordship,
If one avenue is directly closed for you, can you take recourse to another avenue by using that particular suo motu power?
Your Lordship may grant 3 weeks time.
Let us see. We'll grant the stay of the attachment also.
Your Lordship.
Yes.
my attachment order law is in the additional.
No, there will be a stay of the attachment.
Your Lordship.
Yes.
Your Lordship, 3 weeks time may be granted.
Yes, 3 weeks.
Gratefully.
Item 25.
I'm sorry, Your Lordship, I'm in BC here.
Yes. Yes, call the next.
Item 25.
Nobody. Nobody is appearing. None appears in support of the instant writ petition. Let the instant writ petition go out of list, be listed in the first week of January.
Item number 26.
How many? Recent.
Yes, sir.
26?
26.
Here, another Honorable Singh that's under Annexure 1, that is address 62.
Give the file.
Under challenge of ship. Yes, Lordship. They want to have some.
Caveat is already there.
Some Lord, since long Lordship.
Where is the impugned order?
Test starts from page 62, Lordship.
Yes.
That's a no confidence motion. And more especially, Lordship, that is violation of section 24(2)(c). Either.
ठीक. Odisha Gram Panchayat Act.
Lordship 24.
Yes.
May, for my honest senior opinion, the identical matters, Lordship has referred to larger things. And hearing is already completed, and it is reserved the judgment.
Which is a larger bench?
The supply of resolution along with notice. Requisition, Lordship. Here it is requisition. Lordship, there is a conflict in. Lordship.
So let us wait.
But Lordship, one thing, Lordship.
Same thing. Let us
Lordship.
wait.
But then Lordship, I might be.
Sir, out of 18 members, 17 has gone against you.
No, Lordship. No, Lordship.
About,
Lordship.
are you not taking advantage of this Prahlad Dalai?
One of the grounds. One of the grounds, Lordship.
Are you not taking advantage of this Pramod Kumar Sahu judgment?
Lordship, in fact,
So what we find is here
Lordship.
that so far as this mandatory guideline or something of that is concerned,
No.
so one has to understand, and we find the two conflicting judgments to operate. Now the effect of or the nuances of section 24 has to be decided by the larger bench. The larger bench has already concluded and reserved the judgment because one of the issue is section 24.
Larger than Lordship, one of the issues, Lordship, that is so far the service of resolution, but the resolution is equal or not. That is the only point, Lordship. But here, Lordship, I have raised, Lordship, let's come.
Say that you say the 15 days is a mandatory period.
No, Lordship.
No.
No. Apart from that, I have a very golden point, Lordship. Lordship, kindly come to section 24 to 4.
What it says?
Lordship, kindly come to 24.
What it says?
Lordship, it lacks competency. Lordship, can I read? Lordship, before expiring the 2.5 years, Lordship, of my continuous service, you can move for requisition. That is the mandate of the statute.
And and what is the tenure of the
5 years?
5 years.
5 years.
So once half of the period he enjoyed, rest half of the period there is no provision, nothing can be done.
No, Lordship. It only can be raised after 2.5 years. This issue can be raised only after 2.5 years.
It will be permitted that up to 2.5 years he can go on doing whatever the illegalities, whatever the wrong he can do it. He will continue.
24 never speaks of illegality. 24 Lordship speaks.
No confidence.
Or periods only members of the
government. When? What are the grounds, sir? There may be a ground for no confidence. One fine morning, one woke up and then say, I have no confidence in you. There must be a reason. There must be some act, something which has been done. And I find that requisition was made, raising a very serious allegation against you.
Lordship, that can be tested, Lordship, only under section 15. That is not under 24. 24 only political consideration, government changes, Lordship, the 24 comes to play. It never comes, Lordship, without a government changes. 115 is there, Lordship, 26 there. It is power of the collector, power of the state government to take action, to consider the case, not 24.
Something which I don't believe so. It cannot. No. let the decision come.
Apart from that, that issue is not covered in my case, Lordship, because that is a different issue. I can Lordship explain over 2 minutes, Lordship. That you can consider my implement. Because Lordship, that is a scope of resolution is one of the Lordship issue in present case also, Lordship.
Sir,
But I am not.
are you abandoning a plea that the no confidence motion cannot be initiated before 2 years, 6 months?
Yes, Lordship.
Are you abandoning?
Cannot, Lordship. Cannot.
No. Sir, that is the question.
Lordship, please don't deport.
Please, that is what in subsequent judgment, the court has said that the harmonious construction is required. It is not mandatory in all nations.
No one it is decided. Lordship, kindly.
Please, my order.
It is never taken into consideration.
Now, I am telling you, sir, you have not read it.
I am telling it, Lordship.
I am. Please read. The point involved in the instant writ petition pertains to the interpretation of section 24 of the Odisha Gram Panchayat Act 1964. According to the appellant, the modalities and the requirement appearing from the said provision of OGP Act shall be strictly adhered to, and any departure therefrom would entail the action of the authority liable to be caused and set aside, which you are arguing. You are arguing that it is mandatory. In pursuant of the same, a reliance is placed upon a division bench judgment, Prahlad Dolai versus State of Odisha, reported in AIR 2014, Odisha 179, wherein it is held that the copy of the resolution and requisition are twin mandatory conditions, and a departure from any such condition would make the notice issued by the sub-collector invalid.
Yes.
Then our attention is further drawn to an unreported judgment of the division bench, to which one of us is a party, delivered on 15th April 2025, in WA number 3473 of 2020, Prahlad Kumar Sahu versus State of Odisha and others, wherein the harmonious construction was adopted and the intention of the legislature can be reasonably inferred and or seen therefrom. The technicality should not overweigh the fairness and the transparency in the system. We thus find that both the judgments to some extent run counter to each other, and therefore this court feels that it would be proper that the matter would be referred to a larger bench to decide whether the requisition and resolution appearing in section 24 invites any stringent interpretation, and that the requisition resolution must be separate and distinct from each other, or a harmonious construction is required to be adopted, where the purpose of requisition relating to no confidence motion against the sarpanch is evidently manifest therefrom, and the ward members are made aware of the resolution as well as the agenda of this. So this is what we say, that because one of us means me,
Lordship.
they are in the subsequent judgment.
Lordship.
So let us come. They may decide this period may also be said to be non-imperative.
That bench will decide only, Lordship.
There is a conflict. The bench will decide what is the effect of section 24.
Not 24, Lordship. So far, resolution is concerned. 24-2.
I understand, sir. When we say in the first paragraph, the whole of the 24, let them, because the question would be whether this period is mandatory in nature or it is directory in nature.
Is it a full bench, Lordship, is mandatory?
Where?
Lordship, when is it? Every case, Lordship, it is decided.
Show us the full bench decision.
Lordship.
Full bench decision.
Lordship.
That it is inflexible period. Should not.
Only they have decided, Lordship, so the notice period is concerned, service of notice.
That is a different issue. I am again saying, sir, you are taking a plea that this period of 2 years, 6 months.
One of the pleas, Lordship.
Sir, 2 years, 6 months is mandatory, cannot be.
Yes.
Show us the larger bench.
Lordship, that has not been decided. Because that is clear. Lordship, it is appears in the statute. It can be, Lordship, interpreted. Lordship, kindly 24-4 for moment, Lordship. Lordship, kindly say 24-4. 24-4, Lordship, kindly.
Yes, I have seen.
Without prejudice of provisions of...
You wanted me to dictate the order, then I can dictate the order here and now. If you so want, when the shall should be read as may, when the shall should be read as may, when the may should be read as shall. If you want, I can dictate. There is no difficulty. When a period is provided, and then the language which is says, save without prejudice to subsection 3, subrule 3, and then subrule 2. What is the meaning of those? One has to understand.
Lordship, kindly, Lordship. Lordship, may I read, Lordship? Lordship, kindly, I'm first reading, Lordship. I'm starting from 24, Lordship. I'll give you this clear picture, Lordship. Lordship, definitely interfere in my case, Lordship. Lordship, can 24(2) speaks of the intermodalities, Lordship.
Sir, the moment I convince you, you will take time. Then I will not permit you to take adjournment.
Lordship, I want to conclude this, Lordship. Because
You-
otherwise it will be in fractures, Lordship. If I will not argue today, Lordship will not be granting relief today, Lordship.
No.
It will automatically in fracture. So that what I want to conclude this proceeding, Lordship. But to kindly see, Lordship, I would accept resolution, I'll go to other parts, Lordship. Because this judgment also, Lordship, passed near about 3 months. That is only against judgment of Anil Raj case, a recent judgment of Honorable Supreme Court. But you have, Lordship, to set a guideline. Lordship, I'm just raising because the entire my argument was before Honorable Single Church regarding point of law that has never been considered because judgment is rendered after 3 months. Lordship, kindly say 24(2) for a moment again. I'm reading, Lordship. 24(2) in convening a meeting, Lordship. 24(1) on the date of election, I don't enter to argue before Lordship. 24(2) says, Lordship, in convening a meeting under subsection 1 and in the conduct of business at such meeting, the procedure shall be in accordance with such rules as may be prescribed subject to, however, to the following provisions, namely.
Now, please tell me, again, I will say that you will not seek for an adjournment.
My humble submission, they are.
Please, let there be a very valid agreement between you and me.
That's why, Lordship.
First thing is, let us have the first valid agreement.
I have a condition, Lordship. Because
No.
tomorrow, they will, Lordship, kindly see, they have.
No, we will hear you. We will hear you. When we interact, then you will not ask for adjournment.
That's what I know.
That's an agreement I wanted.
But one thing I have, Lordship.
One thing, now come. Now I am arguing.
No, one thing, Lordship. Prior to that, I have one condition.
Yes.
If they have fixed, they have tomorrow for recounting, for Lordship. If Lordship, please, for counting, let them count, Lordship, but no notice shall be made. I will wait, Lordship, till the larger this Lordship comes out, Lordship. So, Lordship, if there is no protection, automatically in fractures, then I will argue, Lordship. Lordship, even Lordship waiting the judgment of the under.
No, I am not waiting now. I agree. It is relating to requisition. I am not agreeing. Let us come and argue. Please. Now tell me how you can make a synchronization between sub-rule 1 and sub-rule 4.
Lordship.
Forget about 2 and 3. Sub-rule 4 talks about 2 and 3.
Lordship, only the occurrence of date of election. Date of no confirmation.
Please come and read. What is the meaning of this?
One I am reading, Lordship.
Please, slowly.
Where at a meeting of the Gram Panchayat, specially convened by the subdivision officer, in that we have a resolution passed, supported by a majority of not less than 2/3 of total membership of the Gram Panchayat, regarding want of confidence in on the Sarpanch or Naib Sarpanch. The resolution shall forthwith be forwarded by the subdivision officer to the collector, who shall immediately on receipt of the resolution publish the same on his notice board, and with effect from the date of such publication, the member holding the office of the Sarpanch of the Naib Sarpanch, as the case may be, shall be deemed to have vacated such office. So, Lordship, it is the consequence of the final meeting, considering the proposed resolution requisition, when the sub-collector fixed date for having to prove having confidence on the leader. Lordship, So the section 24(1) says lordship, it is on the date of meeting, means lordship, it is to be conducted. 24(2) and 4 says, prior to that the formalities, what is the modalities to convene a meeting, lordship, after 15 days. So lordship,
Now question is, if there is a requisition by 2/3 members of the Gram Panchayat,
total members of Gram Panchayat,
then what will happen?
lordship, it will be sent to the sub-collector. Sub-collector will fix a date, lordship.
Can there be any question of any meeting if everybody has come forward and wrote a letter that more than 2/3 majority, everybody wants the removal? Then do you mean that rule 2 and 3 will not?
Lordship, 2/3 comes on the date of meeting. But the 2 said, lordship.
I'm then one harmonious and one interpretation should be given.
Lordship.
That how to work out, because we are in a democratic polity
Yes.
where the majoritarian's view is always embraced and accepted.
Yes.
One cannot think that I am in a minority, but still I will continue and hold the field and control the entire thing. Question is, what I found from the record or the judgment, I have not read. Out of 18 or 19 or 20, 18 members all have gone against you.
That's not
Or except you and the Nayab except Sarpanch.
One is dead.
Not a single person stood by your side.
Lordship, that stage has not come.
The days has not come.
Lordship, kindly permit me, lordship. Lordship, kindly, please come to lordship 115. 115 of that, lordship. 115 of that. 115 of that. Lordship, 115. Yes.
Not a case of.
That is not subject matter, lordship. I will convince lordship. Lordship, kindly, lordship.
Yes.
10 minutes I will convince lordship. Section 115, lordship.
Yes.
Lordship, here speaks of lordship suspension and the removal of Sarpanch,
True.
Naib Sarpanch and the member. If the state government, on the basis of a report of the collector or the project director, district development agency, or so motor or the opinion that circumstances exist so that Sarpanch or Naib Sarpanch of a Gram Panchayat willfully omits refuses to carry out or violates the provision of the act, the rules, orders made thereunder.
That is in respect of a suspension and removal on certain grounds.
Yes, lordship. Then lordship can come to 26. I'm coming on 26 of the act, lordship.
We are concerned with the no confidence.
No confidence.
That's all.
No confidence is not by the voter of the constituency, lordship. No confidence by the members of the constituency. We have lordship come with.
Are you? I'm just asking you. What is the modalities of the election?
In the voters of the Gram Panchayat.
What they chose?
Lordship.
Whom they chose?
Lordship, to me.
No, as
the Sarpanch, lordship.
Is there a specific election for a Sarpanch?
Yes, lordship.
Amongst all the villagers?
Yes, lordship.
Huh?
Yes, lordship.
Or a member of the Gram Panchayat?
All the voters, all the voters, lordship, including the voter list, they used to cast vote in favor of me, and with thumping majority by lordship, all the participants of the Gram Panchayat, I have been elected. But these few members, lordship, they have been elected from the respective wards. Not lordship, they have given vote to me, or on their vote I have been elected. This provision, lordship, this provision is, that's why lordship it is argued.
This is very unique provision. This is what I'm asking. Yeah,
those who
it's a very unique, but in a Panchayati Raj, it does not talk about this.
Those who have not been elected, given vote to me, lordship, few members have been given this power that the mid session of they will, because lordship it always comes when the government changes, lordship.
Where is the provision for a vote?
Lordship, kindly come.
Selection?
Lordship.
Where is the provision?
Lordship, it starts from section 7, lordship. It starts from section 7, lordship. Section says, lordship, 7.
No, I am not. Section says, talks about the Gram Sabha and the Gram.
Come to section 9, parallel election.
I just wanted the election.
Section 10, lordship, kindly see.
That's the constitution.
Lordship.
A member to be elected by the persons.
That's it. Perhaps that's it. 12 lordship and section 2 general election members of Gram Panchayat lordship. Section 12. A general lordship section 12. A general election of the members of the Gram Panchayat shall be completed for the purpose of the constituting a new Gram Panchayat under section 7 of the regulation of the Panchayat.
Used to stand independently. Section 11. Section 11.
11 lordship.
Notwithstanding anything.
Lordship, sorry, lordship. Not anything under section 10 of the member Gram Panchayat are eligible for election. As a surplus, if a candidate for election as a member of the Gram Panchayat respective.
No, I am not concerned with this. I'm just asking a unique, the way of selecting a sarpanch. That's why I'm saying.
All the voters should be done.
Yes.
All the voters are
Yes. It does not say.
Section 2, general elections. Participants of all.
Used to have a qualification for being elected. As a
But this is what I'm reading from COVID 4.1. COVID 4.1.
For one lordship for every Gram
correlate the
lordship. Very little what the voters of every Gram Panchayat lordship have come from. So look.
No, sir. What you say is wrong. The act does not provide so.
10 lordship, 10, 1 lordship.
Yes, that is subject to 4.1.
Yes, 4.1.
4.1 talks about Gram Sasan.
No, lordship that is.
Gram Sasan.
Lordship that is.
It talks about Gram Sasan. Then again, the Gram Sasan talks about the Gram Sabha.
Lordship,
And
gram
also the words. If you look at the assimilate, it does not, because it simply talks is a member of the Gram Sasana or a Gram Sabha. They will nominate and choose among themselves one as a Sarpanch.
Lordship, may I read it once again, Lordship? A Gram Panchayat shall be composed by the following members, namely: 1. A member to be elected by the persons referred in subsection 1, section 4.
This is what I'm saying. Subsection 1 sub R4 talks about Gram Sasana.
No, that is regarding Lordship, electoral list, Lordship. Okay.
Please, Gram Sasana.
I'm reading.
Read.
Nomenclature, but for every gram there, from every gram, there be a gram session. Every gram there gram session, which shall be composed of all persons, all persons registered by virtue of Representation of People Act 1950.
Correct.
There is in so much of the electoral law of the any assembly constituency for the time being in force as relates to the gram, and unless the election commission directs otherwise, the said person of the roll shall be deemed to have been elected in the respect of the gram.
No difficulty. So then you come how it is to be done. What is grammar? Constitution of a gram. Is section 3.
3, Lordship, that is defined, Lordship. Yes, I'm reading, Lordship. Section 3. The state government may, for the purpose of this act, by declaration notified in the Gazette, constitute any village or group of contiguous villages as gram and assign to such gram a name which shall be one of the villages comprised with the gram. So the gram is considered gram panchayat, Lordship. Contiguous villages, Lordship, and the gram panchayat. Then, Lordship, kindly come to next.
Will now come to section 7.
7, Lordship. Yes, Lordship. Gram Panchayat to be executive authority of the Gram Sasana.
There shall be for every Gram
Sasana, a Gram Panchayat as hereafter constituted which shall be executive authority of the Gram Sasana. So, Lordship, the Gram Sasana, Lordship, the contiguous grams consist of few grams, Lordship. It gives the picture of the Gram Panchayat, Lordship, the entire complete shape of Gram Panchayat. And so, Lordship, every voters of the Lordship who is being registered under the RP Act, under the electoral Lordship, they will cast vote in favor of the Sarpanch. They will come forward directly, Lordship. But this members, Lordship.
It's a little digression, but that's against the spirit of Panchayati Raj.
Lordship, Lordship, state to answer, Lordship, but they have state to answer, Lordship. So, Lordship, Lordship, 10B, it speaks of.
Anyhow, we talk about the period.
Period, Lordship.
2 years. 6 months.
Then, Lordship, 24, Lordship, again, 24. So 24, one, Lordship, perhaps I able to convince Lordship. That is a occurrence from the date of meeting, Lordship. So 24, 2 speaks about the entire modality of the election. Lordship, the entire procedure. So Lordship, 24, 2 speaks of Lordship. There must be rules. So Lordship, can this statute, Lordship gives a specific provision for come up with a rule. The state government has not till date 10 rules as the rule. That's why all those difficulties, Lordship. In convening a meeting under subsection 1, and in conduct of business of such meeting, the procedure shall be in accordance with such rules as may be prescribed subject to, however, the following provisions namely. So there must be rules, but they have not come up with the rules. Lordship, the addition to the rules, this condition must be there. Lordship, first condition I'm reading, Lordship.
Forget about the period of this.
Requisite, all formalities.
May I say the restrictive period or a moratorium period, if we can say it.
Lordship.
Tell me. What is the rationale of 2 years, 6 months?
Lordship, they have come up with law. We have not, Lordship.
I am talking about what is the rationale. When we talk about whether this provision is mandatory or directory, we have to consider the rationality in this regard.
Then, Lordship, can you come to set as the constitutional provision? It is, Lordship, there is no rationale. This provision has to be struck down. Lordship, can you come to the
provision? We are not we are simply on the score whether it is directory or mandatory.
Lordship, can you come to Article 243K for a moment, Lordship? Yes.
Yes. 243?
K, Lordship.
Yes. Yes.
Lordship, reading, Lordship. Election to the Panchayat, Lordship.
Yes.
The superintendence, direction and control of preparation sessions, Lordship, the subject of provisions, Lordship. Lordship, sorry, Lordship, 1 minute. Lordship, 243E, Lordship, sorry, 243E. Duration of Panchayat, Lordship.
No doubt about it. It should be filed.
Lordship, kindly come to just recent, just on giving recent judgment of
No difficulty.
Lordship. This is judgment of Sonam Lakra versus State of Jharkhand Lordship. Sonam Lakra versus the police. In that judgment,
Yes. No, that's.
Sonam Lakra versus State of Jharkhand Lordship and Parvati Lordship, Panapati versus State of Maharashtra. Recent Lordship, CJ has hold this judgment Lordship. They are bound Lordship, they will complete, even if that disqualification, they will complete till the tenure is over Lordship. 5 years.
No.
Lordship, so the 5 years.
Again, I am saying
Lordship.
there are two distinctions. The distinction is that at the time of contesting the election,
Lordship.
certain requisite qualifications are required.
Lordship.
Person did not possess any requisite qualifications.
Lordship.
Then the challenge came to
Elected petition. So
he says you can't do it.
No.
Let him continue the entire 5 years and then do it whatever he wants.
Lordship.
Here is a case of no confidence against a sarpanch.
Lordship.
Now the elected members who constitute the Gram Panchayat,
Lordship.
if they think that I have not reposed any confidence now on you, and they have to suffer for 2.5 years, as the law mandates that you cannot raise a single finger on him, you cannot protest for any action taken by him, you cannot raise any kind of an objection to all his misdeeds which he is doing as a sarpanch. Was it the spirit of the section? Or normal circumstances one should not encourage, but in an exceptional and extraordinary cases, why not? Here is an exceptional and extraordinary cases that barring you, everybody of the Gram Panchayat has gone.
No, if not every, not
all the members.
One members will Lordship.
No, 18 members out of 19.
Out of 17 Lordship, only their members are 17.
You are the only person who is spared.
So Lordship, because they belong to different political party.
No.
How did we Lordship? It could have been raised day one Lordship. If they don't have any confidence, Lordship, it could have been.
If they belong to, when you talk about a political party, if they belong to a different political party, they may not have chosen you as a sarpanch.
Lordship, no, they don't have power, Lordship. This power with the voters of the Gram Panchayat.
So why the power of no confidence is used?
Lordship, that is the arbitrary clause. Lordship, enter clause should stop instead of. So Lordship, then Lordship kindly see Article 243G per moment. Lordship, the statute state, Lordship, this 7th Amendment gives power, Lordship, to enable a provision.
Yes.
They have come up with this law. And they have come up with
that is a Panchayati Raj.
Yes.
They are the self
governance
local self-governance is to be ensured. That is one and the different aspect. Again, I am talking about the period. Again, you restrict to the period. Why 2.5?
They have come up with
mandatory.
Lordship,
And why not it is directory?
Lordship,
Depending upon the.
Can the state say, Lordship, it is not mandatory? Then Lordship, every election from the day one, this rule 24 will come to play. Why they have come up with 24 Lordship? Let them answer. Why they have brought up this legislation fixing 2 and 6 months, Lordship?
Yes.
Lordship, could have been 6 months only. So Lordship, this 24 Lordship is and
No, I stand corrected. The recording is that out of 18 ward members, 17 of them have submitted a no.
Yeah, who's the no, Lordship?
Except you.
Lordship, Lordship, I don't have, I can't have any answer.
He has
Lordship,
stated in para 4 of the appeal.
Please, Mr.
Page 7.
Mahaprabhu, let me
He
complete.
has said at para 4. The Lordship may kindly see page 7 para 4.
No.
Lordship, perhaps my friend has perhaps not gone through the legislative intention. This meeting only fixes to have a, to convince my opponents. Again to repose confidence on me. It is not continuous, Lordship. Resolution and requisition with qualification statute gives Lordship only for me to make Lordship to ensure Lordship and to convince my opponents Lordship on the date of election to repose confidence again in favor of me Lordship. So I have a chance to convince them. It is maybe a misunderstanding. It may be miscommunication. So that's why statute gives such procedures. The service of requisition, resolution, and fixing a 15 days clear time, Lordship to make again to pose again confidence on me to convince them on the date of meeting. That's why Lordship the opportunity of hearing is there. That's the right attitude with me to have a confidence on my opponents and to convince them to have again confidence on me. That's why this provision has been made.
Yes. Anything?
Lordship, many things are there, Lordship.
Continue.
So, Lordship,
Opportunity.
Lordship. So, Lordship, in this case, Lordship, kindly consider one aspect.
You are arguing on me on one point.
No, Lordship.
On the point of the limitation.
Lordship,
I am on a point of limitation.
I that is the Lordship, that is the one of the major grounds, Lordship.
That's also let us decide that.
On the major grounds, Lordship. Then I'll come to next part, Lordship. Because Lordship. Lordship.
He's not emanating from civil order.
Yeah, that's my entire grievance. That is like 3 months, Lordship, delay. Lordship, that's why I'm the memory loss. I'm saying, Lordship, because the Honorable Singh last day, Lordship has not, my argument is not taken into consideration.
Please don't read appeal the virus. Number 1.
Virus, no, Lordship.
You are in your prayer.
Lordship, no, Lordship. No, Lordship, they don't know. Virus. No, Lordship.
Where the prayer?
They are only Lordship.
What's the impugn notice?
Impugn notice, Lordship. Notice, Lordship. Notice, Lordship, under this 24. Under section 24, that notice is defective. That's my entire submission. The initiation of proceeding is defective, Lordship. Lordship.
Where is that stand before the
Lordship? Lordship, can you come to my read application, Lordship? Enter my ground of there, Lordship. Read petition.
Reading. This line I also omitted. This line I omitted.
No, Lordship. That is there, Lordship. Lordship, can you state and come to Lordship? That is the one of the major grounds, Lordship. Lordship, kindly see, Lordship, that is.
Where is the?
Para 7, Lordship.
Line has not come.
Prior to that, Lordship, I want to see, Lordship, the death chart. That is at page 7. That is my entire.
8%.
Your cost data doesn't reveal.
No, cost data, Lordship.
One doesn't reveal.
No, Lordship, cost data, I'm saying this entire proceeding is, Lordship. Lordship, kindly come to Lordship, my death chart for page 7.
No, this is the subject.
Lordship, kindly come to section list of dates, Lordship. Second, date 8/2024. That is why the oppositive party what members made a requisition against the petitioner under section 24 OGD Act, which has been ignored in view of this, which has been ignored in view of the section 24(4) of the Act Annex 2 series. So my entire contention, Lordship, apart from all the contention, so Lordship, this issuance, this requisition dated 8/24, it is within the 2.5 years, Lordship, 2 years and 6 months. So then, Lordship, kindly come to a pleadings, Lordship. Lordship, kindly then come to para 7, Lordship. Lordship, that on mere reading of section 24 of the Prime Minister Act, while bringing such legislation, lawmakers consciously has given certain mandatory requirements, obligations for giving effect to the aforesaid provision. And according to lawmakers have fixed following mandatory parameters before unseat and elected representative under GAP Act. In the present context, as per the petitioner understanding, some relevant mandatory requirements has been brought out by the petitioner, which are as follows. No requisition under section 2 shall be maintainable before expiry of 2 years and 6 months from the date of which the Sarpanch of Naya Sarpanch enters service. That's it. Then I have given other grounds, Lordship, which is Lordship, this is the entire proceeding. Then Lordship, right hand Lordship, para 11, Lordship. Para 15. 15, Lordship. I detail I have given. That it is a briefly mentioned that on bare reading of the content of the requisition, which has been duly accepted by the official on 1/12/24 at 12:21 p.m., the contents thereupon reflects by of making some allegations against the petitioner, the signatory of Minati Maji ward member, had stated they have given one requisition on 8/24 by way of a registered post, both the collector and sub-collector on 9/24 and the present requisition dated 1/24 is in continuance with earlier requisition dated 8/24. So it presupposes that the Naib Sarkar, that is the opposite partner of 8, had made an attempt to move no contrary motion by a requisition dated 8/24, and it might have been ignored due to mandatory requirements on such might have. No, but Singhal is not dealt with that part. Even if he is not taken by consider.
When you assume office.
Lordship, on March 2022. I have given the date set.
When the requisition for the first time was done.
Lordship,
November.
Please,
2024.
Please, Mr. Mahapatra.
November 2024.
Lordship, no.
November 2024.
No, Lordship. That is my entire
It was
contention.
taken in the month of December 2024.
No, Lordship. No, Lordship. That part I can convey. Lordship, kindly come to my video. That is on 8/20. No, 8/24. Lordship. It is under misconception. Lordship.
But meeting was not called. Meeting was called in November.
No, Lordship.
Meeting was called on minor.
Maybe, but
16/11.
Oh, no.
I'm sorry. 24/9/2024.
I request my friend not to interrupt.
Requisition was
I am there.
1/6/2020.
Please, you should what, Lordship.
I got it from the single page judgment. Don't worry.
That is the under 30 judgment, Lordship. Lordship, kindly come to page 31 of my writ application. I have annexed the requisition. I have annexed the requisition.
When the notice of no confidence held on the requisition of the authority.
Held, Lordship, that is held, requisition held, Lordship, on 6/12/2024, Lordship.
On the basis of no confidence motion notice.
Lordship.
In February 2024.
Correct. Lordship. So the statute says that.
So I can safely proceed on that basis that though the notice or the requisition was done on 8th February.
Lordship.
2024.
Lordship.
But the meeting was held when requisition by the authority.
Requisition relying upon the requisition 8/2024. Same
I am
requisition.
asking when the requisition for notice, the date was fixed when?
Lordship, sorry, I could not understand.
Date was fixed for holding the meeting of no
I may assist you, Lordship. That is,
by a collector or a sub-collector.
that is on, Lordship, that is on.
What is the date of conducting the meeting?
6/12/2024, Lordship.
6/12.
Resolution is
What I really
24/9/2020.
wanted. So he fixed it.
Lordship.
6/12.
Lordship.
6/12, the meeting was held.
Held, Lordship.
No confidence passed.
Passed.
Correct.
Lordship.
When it is communicated,
16/11/2024.
how can it be?
Yes, Lord. Please
The resolution of 6/12 when it is communicated.
No, no, Lordship, I can answer, Lordship. He should not make this any interruption.
He is again going when the notice was issued on you
Then let him answer.
regarding this meeting of 6/12, 15 days argument. I understand. I do not want that. Please take yours. Do not create any confusion when my mind is very
My
clear.
Lord, 8/2/2012 is not the requisition.
I am
The
not-
requisition is 1/10/2024.
whatever, I will see.
Resolution is 24/9/2024. Notice was issued on 16/11/2024 and date was fixed to 6/12/2024.
That's all. Just take it. Yes. Yes, sir.
Then Lordship, kindly see. If Lordship is very clear, if the Lordship will go to section page 31 of my writ application, enter confusion there. Lordship, because this aspect is not gone through by our
You are
signature.
creating more confusion
I am not creating
in me.
confusion, I am saying the facts.
You are creating more confusion in me by taking me to page 31.
Lordship, yes. 31, please see what are the contents.
What I can see only, but
Lordship.
what is the content I can't say.
That's why, Lordship, my honorable.
That's why I'm saying
Lordship, the judge can.
you have created more confusion in my mind.
Lordship, page 31, my Lordship, the judge can.
I do not know.
Lordship, the section page 31 says, Lordship.
You are talking about a content I can't go
No,
into.
sorry, Lordship, because that is in writ application, not in writ application. I could have been translate the copy. Lordship, page 31 says two difficult, Lordship. One, Lordship, he is renewing his prayer of 8/2024. A Lordship is given by one signature. The requirements under law, there must be 1/3 members of the members of the. I want to your Lordship, doubt Lordship. Lordship, for a moment, kindly see section 24(1)(6). 24(2), Lordship, A kind Lordship, kindly see. 2A. Lordship, for a moment, Lordship. It is Lordship, clear Lordship, doubt Lordship, and 24(2)A, Lordship. That is the requirement of law. I may read Lordship. No such meeting shall be convened except on a requisition signed by 1/3 members of the membership of the Gram Panchayat, along with a copy of a resolution proposed to move at the meeting. So this is the requirement of law. So what are the qualifications, Lordship? There must be a fresh requisition supported with 1/3 members of the Gram Panchayat, Lordship. So Lordship, here no conmotion on 8/2/2024, Lordship. They are not giving a fresh requisition. They are simple filing a representation before the collector. We have given a requisition on 8/2024. Please consider our application of 8/2024 and signed by one member. So Lordship, it is never a requisition. It can be treated as a requisition. In absence of requisition, can the sub-collector treat this representation as a requisition, Lordship? That is the only
What is this 32 onwards?
32, Lordship, 32 speaks of Lordship resolution. 32
Dated
dated Lordship
24/9.
24, Lordship.
At least I can read this date.
Then
24/9/2024.
then Lordship, can you just read the below? Can you read the below, Lordship?
No, I cannot read the.
My Lordship,
I can see.
Honorable brother just can read, Lordship. Honorable just Raman.
What
Lordship,
is
if this is 24/9 or 24 resolution, how can we sign on 1/10/2024, Lordship?
Why not?
How can Lordship
It will always be signed from in a prospective
Cannot be, cannot, it is a resolution. Lordship, it is resolution. It has to be signed in presence of the board members and Lordship giving the date.
Sir, in the meeting, everybody came. You were also there on 6/12. If they say that we did not put our signature, we
No,
were not there.
I am not there, Lordship. I am not there, Lordship. It is a.
But everybody appeared
No, nobody is appeared, Lordship.
in the meeting.
Meeting, because you Lordship can see on 24/9.
6/12, I'm talking about 6/12.
6/12, Lordship, I'll come to that, Lordship. 6/12, that they have confidence. That is just under challenge.
So it is under challenge means
No,
everybody signed
that
and
is-
everybody says no.
Your Lordship to decide, Lordship. Lordship, kindly say the 30.
Mr. Abdullah, I think we gave you an ample opportunity after looking into it and after seeing that it was also after 2 years, 6 months. I think you should rest your case for the time being.
Lordship,
You are a very responsible members of the bar.
but Lordship, I am
You know sometimes the bad cases are to be argued and where to take a test.
I am sorry, Lordship,
And
I
some-
could not convince the Lordship of the Lordship.
That's the
Lordship, because
Because we are a democratic country. We respect the majoritarian view, even if there is a dissent amongst the minority group, minority, I mean the electoral, but it does not mean the majority view should go. We must. be-
Lordship, it is not, but it is content of the statute. This view will go to the content of the
Correct.
statute, Lordship.
Absolutely in accordance with law.
Lordship will go.
These infractions and these.
Lordship, then my last point, Lordship, kindly see, because Lordship
Sorry.
kindly see.
Sorry.
Lordship, last point, kindly see. Lordship, kindly see, come to, Lordship, kindly come to.
And others who are waiting in the queue unnecessarily, they are.
Lordship, kindly come to Annexure 1 for a moment, Lordship. Page, Lordship, kindly page 62.
Let me first dictate then.
No, Lordship,
for the rest of the day.
this point to be, this point to be considered. Lordship, kindly come to page 62.
Yes.
Lordship, kindly.
I am looking at page 62.
Lordship,
Sir. This is.
Lordship, kindly say the date of hearing is 67th. And judgment.
I will not. Anil Rai's judgment, you keep it. Rambali, you have not read.
Yes, Lordship, I have read, I have brought every judgment.
Yes.
Rambali, recent Supreme Court judgment I have read out, Lordship. I have brought, Lordship.
Did
The
not
guideline.
consider Rambali.
Lordship, recent 2000 Supreme Court.
I understand, sir. You are talking about 2001 judgment of Anil Rai.
No, Supreme Court. Lordship, kindly.
Supreme Court judgment. I am
Recent
talking.
recent judgment, Lordship. Relying upon Anil Rai and Lordship, both judgments.
Rambali was not
Yes,
considered.
Lordship will fix the guideline because Lordship, in every
The
case,
Rambali
somebody like
has not
this.
been considered by the Supreme Court in this judgment. I believe so.
Lordship, kindly.
Simply went on Anil Rai.
Lordship, kindly say, it's Supreme Court judgment.
Yes.
In section 20 of the CPC, Lordship has to follow within 2 months the result has to be pronounced, Lordship. And this is the criteria, Lordship. In fact, Lordship, in all cases, Lordship, honorable judges are forgetting our contentions and amendments. And Lordship, we are suffering in every case. The guidelines have to be followed. Lordship has to be.
Rambali has not been considered.
Lordship, kindly come to, but Lordship, the recent judgment, Lordship.
No, I'm speaking about if there is a coordinate based decision of earlier decision, then what will follow?
But
Tell
Lordship,
me.
that is guideline.
What will follow?
Lordship, at least, Lordship, Lordship, we are making arguments.
But
We
that
are-
is not.
we are-
that's not me.
Abutments.
That's not because it is all. You understand?
Lordship, amendments are there and written notice
And
submission
that
are there.
That is also within.
And Lordship,
That is also within 3 months. It has been.
Lordship,
It is done within 3 months. And Anil Rai says 3 months. Because hearing was concluded on 16/7, judgment was delivered on 13/10. So it was within.
2 days. Tomorrow I am coming in 3 days.
Whatever.
Tomorrow I am coming, Lordship, which is 3 days, 3 months. More Lordship.
We consider, but is this case?
It's a
It
very
is
case.
within 3 months.
Lordship, the Lordship is not considering, I don't mind Lordship because the Lordship verdict will bind upon us. But it will be Lordship clear.
So what Anil Rai says that
Lordship.
at least the judgment has to be delivered within 3 months.
Lordship.
From the date of the last hearing. It does not say that the entire judgment will go out or to be quashed. It simply says that in the event that within 3 months the judgment is not delivered, then it should be posted again. And an opportunity should be given to both the councils to argue the matter afresh.
Lordship.
And then thereafter ensure that the judgment is delivered. In the event the judgment is not being delivered nor the matter is listed, then the Chief Justice, as a master of the roster, is a power to take out that file and then place it before him or before any other judge for rehearing of the matter so that the judgment is delivered. It never says that the judgment should go out. That's why I say there is a subsequent judgment to Rambali, Anil Rai. It's a Rambali judgment, which has taken a more pragmatic view in this regard. And nobody takes care of this Rambali.
Rambles,
It's a subsequent judgment. Rambali. Look at the language. Rambali has said. Look. Paragraph 80. I'm reading for all of you. Say, we also find that the plea of delayed delivery of judgment and the same rendering it vulnerable is without any substance. In Anil Rai's case, this court has only stressed upon the desirability of early delivery of judgment. In fact, the judgment impugned before this court in the same case was not set aside on the ground of the delayed delivery of judgment and was dealt on merits. In para 10 and 45 of the judgment, this court has indicated options to the party in case the judgment is not delivered for a considerably long time. We are unable to appreciate that any detriment as such was caused to the appellant on that count alone on a peculiar facts of the case. The court has said that the judgment will not go if we find that everything has been meticulously dealt with.
That's the 2025 judgment. But keeps a guideline considering Anil Rai's case. There is a guideline.
I'm saying nobody noticed the Rambali's observation.
Then Supreme Court again will
says, again I'm saying, if there is a earlier judgment of a coordinate bench taking a particular view, a latter judgment of the coordinate bench taking a different view, then what the High Court should do? Tell. Article 141, what the court will so? It's a latter judgment or it's an earlier judgment?
But my humble view, before Lordship.
I'm asking you.
Lordship, my humble view, Lordship, because here is a case, Lordship, Honorable Singhal has not gone through my content, sir. Has not dealt with my content, sir. At least it will be remanded to him to consider my grievance.
Mr. Deloy, I believe that I have given you at least half an hour, 40 minutes, full opportunity.
No, Lordship, that we in every case we Lordship get from the Lordship that is that opportunity of
there must be some.
they are getting opportunity of hearing Lordship.
Yes, that's so.
But Lordship, my
Then don't unnecessarily
only two lines, Lordship.
argue sometimes. No.
Lordship, only two lines, Lordship.
The difference. Where is it? Paragraph 5. No, I wanted the paragraph 5. This is by Justice Vikramjit sir. Paragraph 7.
7. I'll go through them.
Read loudly for all the members. Yes, Kiran. What it says.
The court and even most of High Court as well as the government courts have to place lengthy arguments in each case because of the practice of citing innumerable decisions on the particular point of law. The correct approach is to dedicate arguments on the decision which votes the field, which in the present case in Tata Cellular versus Union of India, rendered by a 3-judge bench, the rule of precedence, which is integral part of our jurisprudence, mandates that this exposition of law must be followed and applied even coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts. We hasten to clarify that if a coordinate bench considers the ratio recently of previous bench to be doubtful efficacy, it must comply with the discipline of requesting the Honorable Chief Justice to constitute a larger bench. Furthermore, there are some instances of decision even of a single bench, which having withstood the onslaughts of 2 times have metaphor pushed into high authority, demanding reverence and adherence because of its vintage and following in contradiction of the strength of the bench. This is a sufficient characteristics of the doctrine of stare decisis. Tata Cellular has been so ubiquitously followed over decades in almost every case concerning government tenders and contracts that it has attained heights which issued discretion of even a larger bench. Digression of even larger bench. The law of precedence and stare decisis is predicated on the wisdom and salubrity of providing a firmly founding law, without which uncertainty and ambiguity would cause concentration in the society. It generates legally predictability, which simply stated is an essential. Our research has revealed the existence of only one other 3-judge bench decision which has dealt with this aspect of law, namely, they refer to cases, which is in actuality and anthology of all.
Lastly, it's what it says, that it wasted the court's time, invested the court to take a decision.
Failure to follow the discipline and inexorably leads to prolongity in judgments, which invariably is a consequence of lengthy arguments.
You should.
But let's see.
That's a very apt observation. So I wanted to brought to your notice this the Supreme Court has held.
Tomorrow I'm coming with a good case. Let's see.
I know. I will keep it with you.
Item 30 minus from today's lesson.
Come on.
Lordship, item number 25 Malot, I'm appearing online. Lordship, item number
Tomorrow, I think, tomorrow. Otherwise, will be reverted.